Court of Appeal for the 6th District of the State of Florida is now in session. The Honorable Mary Nardella, Judge presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Yes, go ahead, Judge.
Good morning. My name is Mike McKee. I am a circuit court judge here in the 20th Judicial Circuit. I want to do a brief introduction before we get started here today. I know we have a number of students that are here from FGCU. First off, I want to thank the judges of the CCCA for coming out of the county to provide part of our quality celebration here. I want to tell you a little bit about the CCCA as well as the judges who are providing here today. Chief Justice Charles Kennedy for the federal workers take a look at the appellate practice in Florida and take a look at the jurisdiction of Florida. For the first time since 1979, they made a change and they created the CCCA. And in 2022, the legislature approved those recommendations and created the CCCA, which began operations January 1st, 2023, becoming the newest appellate court in Florida. The CCCA serves over 3 circuits, the 9th, the 10th, and the 20th case that starts in Collier County, goes up the west coast of Florida, kind of goes east of US 17, included Lakeland, which is the home of the court, and then goes on I-4 and includes Osceola in Orange County. The 3 judges that we have here today provided Judge Nardella. She is a double graduate of the University of Florida. As an undergraduate student at the University of Florida, she was inducted into Florida Institute, which is a prestigious organization that recognizes great leadership of their undergraduate students. She went on to law school, took the bar where she scored so high that she was asked to speak at the 5th UCA swearing-in ceremony of the new lawyers that were being sworn in at that time. She went on and did a complex civil litigation practice, and then also did estate and trust, which I know there are a lot of people who are very happy to have someone who has an estate and trust background on the court, because it's relatively rare, quite frankly, in this position. Next, Judge Brownlee. She was a scholarship athlete at Hamilton, where she played volleyball. She went on to FSU, where she graduated for law school, where she graduated with honors. She practiced basically what the attorneys do up here in Frenchville practice, which is an appellate practice. So she's very familiar with what the lawyers do in front of her, what it takes to be an appellate lawyer, etc. Last but not least, Judge Jones. He went to the University of North Florida, where he was a different kind of appellate as well. He then went on to the University of Florida, graduated from 11 School of Law. He also practiced a complex civil litigation background to transition into an appellate practice as well, where he concentrated on constitutional law, arguing cases all the way up to the U.S. Supreme Court. And so I want to thank our 6 DCA judges for being present here. I want to thank all of you and welcome the students from FGCU. And thank you very much.
Thank you so much, Judge McKee. We really appreciate your hospitality. We're so glad to be part of Law Week. So I want to thank and welcome everyone to an oral argument session of the 6th District Court of Appeal. We're going to have 4 cases that are going to be heard today. For those students and members of the public, if you would like to stay till the end, we'd be happy to answer any questions you have generally about the profession. We can't answer any specific questions about the cases. If any of the attorneys who are arguing today would like to stick around as well, I'm sure the students would be happy to speak with you and ask you questions as well, but we understand you guys are all busy practitioners and have places to be. So with that said, the first case that we are going to hear today is Carla May St. Angelo versus Jennifer St. Angelo Hughes and Christopher St. Angelo, and it's 25-1398. As counsel is aware, each side gets 20 minutes. Counsel for appellant, would you like to save your time for rebuttal?
I would.
Is 5 minutes?
5 minutes is exactly what I was thinking.
Okay. Whenever you're ready, counsel, you may proceed.
Thank you. Good morning, and may it please the court. My name is Bob Goldman, and I represent Carla Santangelo, the decedent's surviving spouse. As we reserve the 5 minutes, I also want to indicate to the court that we rely on our initial and reply briefs in addition to our brief dialogue today. The broad issue in this case is whether my client can seek a determination of estate assets, and that depends wholly on her standing as an intestate heir. That issue has been decided in her favor, being a surviving spouse and having an intestate share as a surviving spouse in 5 different final orders in this case. The original order on the petition for reformation, the amended order on the petition for reformation, which found its way up to this court in 2023, an order on rehearing of that amended order that was never appealed, and an order on the petition for family allowance and exempt property, where part of the antenuptial agreement was interpreted, including the part where the court found that she was a surviving spouse and had an intestate share. The 2 final orders under review stem from 3 petitions that my client identified, that are identified in those orders, and they basically pertain to the nature of the assets and her entitlement to them, and whether she has a financial obligation with respect to those assets. My client timely noticed those petitions expressly for an evidentiary hearing, but that never happened, and in part because the court hearing those petitions was a new judge to the case, and understandably, I think, wanted to understand the history of the case and the extent to which his jurisdiction was limited as a result of prior rulings of the predecessor judge.
Counsel, as to your argument regarding the requirement to have an evidentiary hearing on the issue, can you elaborate for the court what evidence you would have introduced at an evidentiary hearing?
Sure. Taking just a couple of examples on the petition to determine assets, that involves a business known as Seminole Prairie. Is Seminole Prairie a separate entity, or simply part of another entity owned by the estate called Okeechobee Outfitters? So all of that needed to be considered. Also, the son of the decedent claimed that that entity was, if it's an entity, was in fact gifted to him prior to death. So Florida corporate documentation from the state of Florida, evidence of a gift or not a gift, tax documents showing the Seminole Prairie assets as being part of Okeechobee Outfitters, testimony of the CPA that dealt with financials related to those businesses, and testimony by my client, the manager of Okeechobee Outfitters. That's one example. With respect to the petition related to the mortgage on the property and the note, that involves, of course, those documents and the history of those documents because they changed. The nature of the title on that property, what that debt was used for, in fact, and how the mortgage was paid, and again, state court documents, tax documents, financial statements of Okeechobee Outfitters, and my client, again, as a manager, and what was intended by the creation of that debt. She was not on the title to the property. And also testimony of the CPA and the decedent's son on those issues. So those are examples, Judge.
Thank you. Did you need to make the trial court aware of the reason you needed an evidentiary hearing and what you would hope to do with an evidentiary hearing after they proceeded without one?
I don't think we were in a position. The trial transcript is very short, easy to get through, and I think, anyway, it's crystal clear about what he wanted, which was, in fact, an understanding of the history and our observations of prior orders and whether they amounted to and bound him as the law of the case. We understood it was going to be bifurcated. We weren't objecting to that, that simply made sense. So there was no position in that proceeding. We thought we were going to an evidentiary hearing afterwards. What we got was final decisions as though there had been an evidentiary hearing. So there was, at no point in that was there something to object to, something to proffer. We were waiting for an evidentiary hearing, and in fact, and it's in our appendix, the proposed order we sent in at his request, again, contemplates that there will be an evidentiary hearing subsequent to the court's review of the memorandum and deciding on the limitations, if any, to its jurisdiction.
Counsel, does any of that evidence that you weren't able to put on, does any of that matter if, apart from the legal determination that Ms. St. Angelo is entitled to an intested share? In other words, if she's not entitled to an intested share, does any of that evidence matter at all?
It really doesn't. I mean, that's the whole point, is the standing is everything in most proceedings and this one as well.
So can you just kind of pinpoint for us, I understand your argument is that the legal determination that she is entitled to an intested share is law of the case at this point. Can you pinpoint for us where that determination became law of the case such that it could not be departed from afterwards?
Sure. I can, and if you, when you're thinking through the case, if you go to my appendix at pages 18 through 34, you'll have those orders. But to answer your question directly, when this court affirmed everything but the appointment of a personal representative with respect to the amended order, that became law of the case on that issue. But actually, before that even, it became law of the case because the order on rehearing, where the court clarifies and makes clear this is an obligation of the estate, this is her entitlement to this share as a surviving spouse, was never appealed. And then again, on the order determining the exempt property and family allowance, as part of, correctly, I think, as part of an interpretation of paragraph 3.07 of the prenuptial agreement, the court goes through and makes findings about her intestate share, as well as deciding that's one thing she gets, but what we take it away under 3.07 is her right to exempt property and family allowance. So in those two cases, neither one being appealed, those became law of the case, but then this court's order also.
So, counsel, in your brief, you cite the case law, DCA case law, to the effect that law of the case would include issues that could have been taken up on appeal but weren't. I think that would, that category would include the rehearing motion that wasn't appealed, and it would also include, I guess, within the order that was taken up on appeal, issues that were not raised to the 6th DCA. But I look at the Giuliano case out of the Florida Supreme Court, the 2001 case, and to me that case rejects that concept and says, I'll just quote from it, the law of the case doctrine is narrower in application in that it bars consideration only of those legal issues that were actually considered and decided in the former appeal. So when we look at what was actually considered and decided in the appeal to our court,
Sure.
Can you pinpoint for me where in that decision and what we actually decided would establish law of the case on that issue of the her entitlement to an intested share?
In all other findings, we affirm, is what this court said.
But wouldn't that matter, wouldn't that still be limited to what they raised in that initial brief? So,
No, respectfully, Judge, I think what matters is what the court found, and then this court and the whole order was on appeal. What they decided to argue in their briefs or not argue in their briefs, I don't think matters to that point.
but we wouldn't go out and just find a new issue. We're not looking at findings that you all might argue were incorrect findings or
Right.
findings unsupported by evidence. So if y'all don't challenge that, we're not just going through unless there's some, I don't know. I mean, I can't, in the case, in this civil case, I can't envision a situation where we would just go through and say, that finding was right, that finding was right. Like if it's not our role to go out and find those issues
and determine whether we think they were properly made, regardless of whether you argue it on appeal, we're not really deciding that, right? In that way, in my mind, we're limited to what the argument was in the initial brief. And then, if our court writes, well, as to that, we affirm, it's still in that box, right? It's cabined by the issues that are raised in the initial brief.
Respectfully, I think what you're limited by is the order, not what a particular litigant chooses to put in an initial brief or not. And what the court did, the finding, and if you look at the appendix at 18 through 20, you will see a finding by the lower court that Ms. Santangelo was indeed a surviving spouse entitled to her intestate share. That was affirmed by this court, by its order. That's what you're doing. You're reviewing the entire order. I agree you're not going out looking for other issues. No, they're right there in the order. And the question is, are you affirming those? Which I believe, well, I know you did.
But counsel, the only two issues raised in the first appeal were, is your opponent entitled to reformation, right? And can Ms. St. Angelo be the personal representative? Those were the only two issues raised. I know the order made other findings of fact and legal conclusions, but the only two issues raised were those two before this court.
Well, if you look at it that way, Judge, then to go back to Judge Ganem's question about law of the case, then if the issue of her determination as an intestate heir, as a surviving spouse, was not appealed, then it too was law of the case at that point in time. Nothing changes on that.
But isn't that contingent on rejecting Giuliano and accepting Wharton versus Washington, the second
No,
case?
it's contingent on final orders being final orders and being binding on the court, whether it's res judicata, whether it's law of the case. You can't change the final order. And that was the final order. And using the theory that that particular issue of the judge was not appealed, then it became a final order and was binding on the successive judge, which is the key point. The reason we are here on a more specific set of points on the initial brief, we discussed the due process provision and the fact that it's, although I gave you at your request evidence that would be presented, whether the quality of that evidence is important to this court or not is not an issue. The question is having the right to present that evidence and the closing argument.
Counsel, does your briefing, if you can just remind me, does your briefing walk through that evidence and say, because sometimes we see like in a 1.540 motion where you need an evidentiary hearing, and I might be like misquoting that, and I'm sure there are exceptions that aren't coming to mind right now, but sometimes there's sort of like a blanket rule. And then sometimes you just need an evidentiary hearing because there's some disputed issue of fact, and therefore it needs to be resolved by the court, at some evidentiary hearing. But in your briefing, did you walk through that and sort of articulate, well, okay, I've got a disputed issue of fact as to what the business is, for example, and that needs to be resolved in order to make this factual finding, which then bears on the conclusions in the case. And if you didn't do that, wouldn't it be hard for us to find prejudice, for example, or harmful error, or to make any assessment as to whether an error was actually committed by the trial court in failing to hold an evidentiary hearing?
Well, getting to your last point first, the unique problem in this case is we thought we were going to an evidentiary hearing that never happened. There was no point where the court said, okay, now we're having an evidentiary hearing, and here's what you can do and what you can't do. So without a record on that, there was nothing really to brief and nothing really to talk about on that other than the fact that we tried to have an evidentiary hearing and we were not allowed to have one. And what the case law says that is cited in our brief is that's the end of it. And by the way, this isn't about harmless error or not, because that involves questioning what evidence would be there and what wouldn't. And that's not the point. The point is it's a fundamental due process error.
But it's not always a fundamental due process error, right? Like, if you don't have a dispute, for example, if you had a mortgage, and say hypothetically that the question was whether she's on the mortgage and has some obligation to pay, right? The other side might not dispute that, and so you could just sort of check that box and move forward with your argument, and you wouldn't necessarily need an evidentiary hearing.
Well, sure. If there's a
Okay.
stipulation, what we want an evidentiary hearing. Well, no, you don't get one then because it's been agreed to. I totally get that. Absolutely. That is the case.
Thank you.
Counsel, you're in your rebuttal time. If you'd like to keep going, you may.
You know what? I'm just going to, I always watch judges talk about this, so I want to tell you what I want. And if that goes into the 5 minutes, then that goes into the 5 minutes. Based on our initial and reply briefs and today's discussion, we ask that the court reverse the 2 orders under review and remand for an evidentiary hearing with instructions that Carla Santangelo has standing as the holder of an intestate share of her husband's estate, and then instruct the court to proceed with the evidentiary hearing on the 3 petitions. Thank you. 3 minutes left, maybe?
3 minutes, 37.
Okay.
Counsel, whenever you're ready.
Good morning. May it please the court. I'm Steve Sen, counsel for the adult children of the decedent Daniel St. Angelo. This is the 3rd appellate review by this court of the administration of Mr. St. Angelo's estate. The first one we've talked about was an appeal of two issues, and one of them was reversed, and the other was affirmed, and it was sent back to the probate court for further proceedings. In the course of those further proceedings, there was a lot of argument about what did the 6 DCA mean in that first panel, and how should the probate court wrap up the other issues that had to be wrapped up consistently with the guidance that this court provided. And in fact, the probate judge asked the parties to submit memoranda on what was previously decided and how that governed what would go further. The wife was unhappy with the resolution of some of those decisions and came back to the same prior case with a motion to enforce the mandate. And in that motion to enforce the mandate, the argument was made that these subsequent decisions were law of the case. Now, we said, well, you can raise an appeal if you want. This is probably not the best way to do it. But this court didn't dismiss it. This court denied the motion and basically made, and that is a decision that itself is law of the case. And so as to the law of the case issue, law of the case is against the wife's position that law of the case is in her favor. This court has already decided that these subsequent decisions do not violate law of the case when it denied her motion in that regard. So that issue, we think, the law of the case issue, is ironically barred by law of the case. Here on the, and that was a correct decision because it was that those issues had not been raised in the prior appeal, and the Giuliano case, as well as the Delta property management case, more recently made clear that these decisions that were not, anything that was not actually raised on appeal and addressed by the appellate court is not law of the case. As to the due process issue, that was never raised in the trial court, and we've heard the explanation that, well, you know, we got this order and we never had an opportunity to present evidence. But the whole theory of an appellate court is that you are reviewing decisions of the trial court for legal error. And in the absence of a decision, you generally don't have anything to review. Here there was no decision by the trial court. That was never asked to consider any evidence, was not proffered any evidence in the trial court. No argument was made as to what that issue would be relevant to. And so you're here asking to review something that happened that the trial judge did not have anything to do with. With regard to whether that might have been raised after the fact, well, this court and the rules have developed such that when you get an order that has what you think is error, that had not previously been part of your arguments at that level, then you need to give the judge a fair chance of hearing your arguments and letting the judge decide it. And I would argue that that's especially the case with regard to evidentiary issues, where review is for abuse of discretion. And here, there was no argument, not in the trial court and not in the appellate briefs. Here, for the first time today, we are told that it may have been relevant to this Okeechobee Outfitters issue. But there's not been a dispositive ruling by the trial court on where Okeechobee Outfitters is going to go. There is a pending motion that has not yet been set for a hearing. So they will have the opportunity in subsequent proceedings in the administration of the state to present whatever evidence in front of the probate court they think is relevant and appropriate to that issue. The issues here, it's two issues, but the primary issue of whether the wife, there's two issues. One, should there have been evidence admitted to show that the wife should have received this property free and clear of a mortgage? That's just a straightforward application of the plain terms of the antenuptial agreement. And under those plain terms, it didn't say, and the probate judge said that he was specifically enforcing it, but it doesn't say she gets the home and 5 acres free and clear, or that the estate must pay off any mortgage on it. It doesn't say that. And so that would be any evidence to try to change what the document said, what the agreement said, would be in violation of the parole evidence rule, and would not be, even if the issue had been raised, the judge would have been well within his discretion to disallow that evidence.
Counsel, let me, if I could stop you there, while we're on the subject of interpreting paragraph 3.07 of the prenup. Apart from that language about devising the marital home, there's a language that precedes that, which I understand your clients tried hard to get reformed, to read that basically, each party can dispose of by will whatever they want, but in the absence of that, then the property will, say, I'll just read it. The estate of each party shall descend to the heirs of that party. You wanted it to say as if the marriage had not taken place, which would have meant one thing, but that wasn't successful. So we have the language that we have, and it says the estate shall descend to the heirs of that party as if the marriage had taken place. What are we supposed to do with that language now, understanding that that's what the contract says? How do we interpret that? What does that mean?
Well, I'll tell you what the probate court did, is he said we need to look back at what the 6th District said, which is to look at the more specific waiver of all rights earlier and find that that governs, because the language that you're referring to does not specifically say that the wife can take an intestate share. And in 3.01, the parties do hereby waive and release all rights, including the right to any distributive share. So if you're trying to figure out what that admittedly confusing language means, whatever it means, it has to be harmonious with the very specific waiver of a distributive share of the estate in 3.01. That's what this court did in the first panel opinion, is you said, okay, we see this back here, but these waivers up here have to be enforced, and when you do enforce those more specific waivers, to the extent that they aren't expressly restricted by 3.07, then in that case, the court found that the probate court erred in appointing the wife to be the personal representative of the estate. The arguments to the probate court below were that you apply that same analysis, and if you apply that same analysis, then you get basically the same result. 3.01 governs because it is by far the more specific language dealing with that, and there was nothing in the prior decisions of this court or the prior decisions otherwise to the contrary. Now, this argument that there was some kind of dispositive finding earlier on that she was entitled to an intestate share, if you look at the orders, it doesn't really say that. It says that she may make a claim.
I'm going to back up and go back to the language again, because I understand your argument, and assuming that we interpret our prior decision in this case, where it says that 3.07 at most simply revives the wife's right to take under the laws of intestacy. Your argument is it doesn't even do that. And so if we have some obligation to read all the provisions to give effect to everything and to avoid as much as possible superfluous language, what should we construe that language to mean? If it's not to reinstate her right to an intestate share, what does it do?
Respectfully, Judge, that issue is not before you. We are here on the two issues that have been raised, law of the case and due process. There is not a general appeal that the trial court erred in his construction of the agreement. That is not one of the issues that's here, and I don't think it would be appropriate for the court to consider an issue that nobody has raised. It was all argued certainly at the probate court, but here we've got law of the case, which we've talked about a lot, and due process. And unless one of those two things was reversible error, then this court should affirm. On the due process issue, that was never argued below. That's being raised for the first time on appeal. And as we argue in our brief, there was no due process violation for the simple reason that you don't get to just present evidence without limitation or restriction. There's lots of rules that govern it. Generally, for due process to give you a right to introduce evidence, there has to be a disputed issue of fact that is relevant to the outcome of whatever relief somebody is seeking. And we did not hear until today what issues might be presented. And quite frankly, as to those issues, those weren't decided yet by the probate court. Okeechobee Outfitters is still in play, is still to be determined by the appellate court, and we would urge the court not to address issues that have not been raised in the briefing. Particularly, I mean, you certainly can do that to affirm, but you particularly should not do that to reverse. So issue 1 is not preserved because the probate court never issued any ruling excluding evidence, and issue 2 is barred by law of the case based on this court's prior denial of the motion to enforce. We have other issues in our briefing, but I believe those points should be adequate to affirm the decision of the probate court unless there are other questions from the court.
I do have a question, counsel, about your application for attorney's fees. Looking at Townsend versus Manfield, can you address whether this court has the power to grant you attorney's fees in the probate matter?
I think not. We did it in an abundance of caution, and we kind of reviewed the law about how that developed. It was in the Constitution, and then it was out of the Constitution, but it's still by statute. And then I think this court has a precedent on that, which when we moved for fees after the court denied their motion to enforce the mandate, we had a motion for fees on the motion to enforce the mandate. And we filed very similar motion there, which we talked about the uncertainty in the law, and this court issued an order, and we have filed that in this case. It was issued under the other case number. Filed that in this case where you basically deny it without prejudice for the probate court to consider. And I think that's the best answer, but given the uncertainty in the law, and at the time we did our prior motions, we didn't even have that. So but that's what we think the right answer is to deny that without prejudice and to allow the probate court to address it. If there are no other questions, I thank the court for your attention.
So what I'm learning is everything's okay because all of my client's petitions are still in play. The problem is her standing, and that is her intestate share, which she must have, and which the court denied, even though there are 5 orders that say she's entitled to it. And I disagree with my learned friend about those orders being vague, particularly the order on rehearing. It clarifies in precise terms that she's entitled to her intestate share as a survivor spouse. The court did that again with respect to the family allowance and property. So to say that it was vague is just not accurate. Now,
So you dispute that it simply said that she could challenge it later or they would address it later, and you think that an express finding was made in that regard?
in the rehearing that was never appealed, and in the exempt property order that was also never appealed. 100% precise. If it was vague at all in the prior ruling, it was not on rehearing. Please read those orders. They are part of our appendix because they could not be more clear. As vague as the other one might have been, these are crystal clear.
Counsel, your colleague has described your initial brief as really focusing on law of the case instead of the trial court's substantive ruling.
Yeah.
I share that read. Am I wrong? Have you challenged the substantive ruling of the court on the interpretation of the antenuptial agreement when it comes to her intestate share?
No. What I have done is argue, again, that we were entitled to a hearing on all of this, an evidentiary hearing, and to say we didn't preserve it. We did what one must do. We did a notice specifically of an evidentiary hearing that never was permitted. We were not in a position to be able to address that. I wanted to come back, Judge, if I may, to the argument about the enforcement of mandate and the court's denial of that motion as somehow being significant here. The enforcement of a mandate, as this court knows, is a simple juxtapose the mandate with a ruling, and on a ministerial fashion, was it effectuated by the lower court. That has nothing to do with the due process arguments. That has nothing to do with the rehearing order that was never appealed. It's not part of that case. It's nothing to do with the family allowance and exempt property issue. Nothing to do with any of that and the pending petitions. There's some sort of argument that we should have done something more, and this is just in all the cases they cited, for example, on the proffer of evidence. There was an evidentiary hearing where objections to evidence were sustained and nobody proffered evidence. That's not this case, because we waited for an evidentiary hearing and it never came. Did we somehow, which they say in their brief, we needed to raise that in rehearing? Not in a non-jury case. 1.530 is crystal clear on that you have the right, but you are not required to do that to preserve an argument. Uniquely, in this case, 1.530, I think, does apply because our petitions relate to determination of beneficiaries, which is a term of art under 733.105, and all of our petitions qualify for that. So those are deemed adversary under Rule 5.025. Thank you for your time. I see I'm out of time. Thank you.
Thank you, counsel, for your argument today. No need to rush. I'll go ahead and call our second case, and they can come up at their leisure. It's Lee County, Florida versus Captiva Civic Association, Inc. and WWSSIR Owner LLC.
Judge, I wanted to apologize to you guys and to the students. I'm not going to be able to stay. I'm going to stay for part of this argument coming up, but then
Oh, we completely understand. All right. I'll try calling it again while you guys get comfortable. Our second case today is Lee County, Florida versus Captiva Civic Association, Inc. and WWSSIR Owner LLC. It's case number 25-0335. As counsel is aware, you're permitted 20 minutes to make your argument. You can allot a certain time for rebuttal. How much time would you like to reserve?
I'd like to reserve 4 minutes for rebuttal.
Whenever you're ready, counsel, you may begin.
May it please the court, my name is Chris Altenburn. Along with my partner Eleanor Sills, who could not attend today, we represent Lee County. At appellant's table is Hala Sandridge, who represents the intervener SSIR. She won't be arguing today. Technically, she's an appellant, but, she's an appellee, but on these issues, she is more aligned, or her client's more aligned with the county than it is with the Civic Association. This case involves the interpretation of a contract that was signed by Lee County and by the Captiva Civic Association. That contract's a mediation agreement. was filed in circuit court in 2003 to settle a then pending lawsuit. The sole consideration for that agreement was the dismissal of that lawsuit. No judgment was ever entered in that lawsuit, and the mediation agreement itself was never ever reported in public records to give anyone in the public notice that it existed. But 21 years later, the Civic Association filed a lawsuit against Lee County, claiming that one sentence in the middle of paragraph 3 provided that the association had a vested legal right at any time in the future to block the county from issuing a building permit in the event that in the South Seas Resort District there were more than 914 dwelling units. Now, 914 dwelling units was at that time, because of the land use code and due to a resolution passed in 1973, it was the limit of dwelling units in that particular zoning district. But the association is claiming that not only does it have a vested right to do that when that is the law, but that even if the county commission has or in the future changes the land use code to some other density, it still has the right to enjoin the county, the building department, from obeying the lawful ordinances of the county commission, and to prevent a then property owner of the property in question, who has fully complied with all applicable laws to be able to obtain a building permit, that it can prevent that building permit from being issued.
Am I correct, counsel, that there's nothing in the mediation, or do you concede this or not, that there's nothing really expressly limiting in the mediation agreement to current codes or existing ordinances? You know, there's no language, I think, that would really help you probably in your argument, you know, unless and until the ordinances change or something like that. I mean, it seems to me that if you just took the mediation agreement at face value, we just look at the plain language, I'm not even sure we have to myopically look at certain sentences in there. It seems like there's nothing truly limiting it to existing codes. You contest that?
What I contest is how we interpret this under Connage. And the trial court used the plain and unambiguous standard, and I would suggest that even under Holly versus all, this was incorrect. But that standard, as you know, goes to first principles, and the words of the governing text are paramount concern, and what they convey in their context is what the text means. And in doing that, you take a look at all the textual and structural clues that bear on the meaning. So in this case, this one sentence, and specifically the words "at any time," are in the context of a mediation agreement that's settling various things related to the contract. I do think the contract, by the way, is part of the context. I don't think anything beyond this agreement and the complaint are part of the context.
You think the complaint's part of that plain language that we're to construe?
I don't think you can read the mediation agreement, about 2/3 of it, without understanding what the complaint does, because it's resolving things that were disputed there. So, for example, on the language about there's 104 or 2 units in one of those dwelling buildings, well, that was a fight over whether it was that number or that they thought it was a higher number. So it's really hard to look at this agreement as a mediation agreement, knowing how they're prepared to look at it without at least taking a look at the complaint itself.
Could you prevail just with regard to your argument about interpretation if we decline to look at the complaint because we would disagree, if we disagree?
I think so. I think so.
Okay.
I mean, I think it's kind of like an exhibit, though, so I think you should. But even if you don't, if we take a look at this agreement for the clues as to what's going on, their argument is, now keep in mind, no one's claiming this was something that was in that complaint or that they were mediating to resolve that they're claiming that they could have this right, even though I pointed this out, not only did they not raise it in the complaint, but no trial court would have ever given them this right to have the ability to control the building department when the law allowed for that to take place. So we're dealing with an agreement that they say is, well, it's outside the complaint. Fine. You can do that in a mediation agreement. I've done that in a mediation agreement. But you know, when it's something as huge as giving control of the building department to a nonprofit association, you'd think it would be in a little paragraph of its own that said, in addition to settling the things that the mediator is settling in the complaint, that we're going to give them this vested right for the indefinite future to be able to prevent a dwelling unit to be permitted for a property owner under existing law, because at this time, we're agreeing that there's 912 dwelling units. And that's just, there's no clues in here that this major agreement is in this one sentence in the middle of a paragraph.
Counsel, I'm going to ask this inartfully, so bear with me. Is this akin to somehow a contract which gets pieced together by multiple communications? Is that similar to your argument, or we look
Well,
at?
we've all mediated cases, I suspect, and we don't honestly know whether they sat around at a table and talked to one another, or whether it was a mediator bouncing back and forth in 2003 on this. But what we can say is that the context of how you prepare a mediation agreement is often very, very different than if you were preparing a real estate closing or some other document. So I don't know how this was pieced together, and that would, I guess, require parole evidence if it was needed to do that. Does that answer your question?
Somewhat, thank you.
Okay.
Counsel, can I ask, as the term, building permits is used in the mediation agreement, generally, how would a building permit be obtained in Lee County? I assume it goes through some department of the city, community development or something. Does that then go before a full commission, or is it purely an executive function? Is it also legislative?
The record doesn't tell you that, but
I assume the law would tell us if I dug into the code. I think you could just
yeah.
sort of
Well,
summarize
and
it
I
for me.
can say I was raised in a construction family. The permit is issued by the department. You file all your papers with the department, and they do things within the government to do that. But it's not going to go back to the Board of County Commissioners or whoever is in charge of a municipality to have a vote every time about whether we issue a building permit. That does not happen.
Who is the decision maker then, apart from this agreement being in effect? Who gets to decide whether someone who wants to build on in this South
It's
Sea
gonna be
Resort
s-
District?
I can't tell you the precise descriptions in this situation, but it's going to be someone in the executive branch of county government that is applying the local law under those ordinances and anything that would be applicable under Florida statutes. That's how this is going to work.
And if there's a proposed builder who presents an application and it complies with all building codes and all ordinances, is there discretion on the part of the county to say no, even
No.
if all obligations have been satisfied?
The property owner has property rights that are given to them in the Florida Constitution by the U.S. Constitution. So if you comply with all laws to do something that is on your property, you're entitled to do it. So they can't say, well, I wish there was something more in the building code or the land use code, so I'm not going to give you a permit. That's just not legal.
And so
Makes
I'm
sense.
kind of leading you down a path here. My question is, how could this agreement, even in the context in which it was entered into, how could it ever be enforceable to tie a county's hands like this to say, we, by agreement with a private association that isn't even a landowner itself, we will agree not to issue building permits, even though they may someone who applies for the permit may otherwise be entitled to it?
Yeah. The answer is that they can't. You're jumping sort of to what I think of as my second issue, which is even if this thing had been written with the paragraph that says, and moreover, in addition to settling the lawsuit, we're going to give you a vested right so that even if we recognize that 914 is what you allege in your complaint and what the law actually is right now, but even if we change the law and make it 1,003, you can keep this at 914 forever, I guess. If we wrote that contract, it's quite patent that we are delegating the power of the county commission to provide the executive branch of local government with guidelines that they're supposed to obey. Those are police powers that we're delegating to a private citizens association. And there's no question that zoning is a police power. So all of the case law that deals with the fact that governments from the highest level to the lowest level cannot delegate their police powers would say that this contract was an ultra-virus, unenforceable contract.
So would your argument be, if this contract was enforceable at all, it would only be in the context of resolving a disputed interpretation of the existing zoning ordinance at the time
Yes.
as to the number of
Yes.
units allowed?
The reason it's the second sentence in this paragraph is the total number of dwelling units in South Seas is limited to 912. Well, when they're writing that sentence and signing the agreement, that's absolutely,
Present tense, right.
absolutely is what it is. It doesn't say is and will be or something like that. The next one about no building permits being issued is because they've been having this fight about, in fact, there were building permits that were issued above this number. They're not going to do this anymore. And because they don't know how many, there's been this fight about unit counts. How do you count to 912? They were trying in their complaint to get rid of determination number 1 in the entirety of the July 30th, 2002 administrative interpretation. But in the mediation agreement, they said, at least as to determination 1, we're conceding on that, and that's going to control. And then they went on to do the last 2 on these things. So when you fit this sentence into the paragraph, that's exactly what they're doing under 912. And it doesn't say because that's the law right now, but that was what they were settling was something that was related to the law at that point in time. So that's my position as to why, if you look at the text in its context to see what meaning it was conveying, it's at this time under this law. It's not that at any time in the future, no matter what is changed, we get to control these contracts. That would be pretty outstanding. Keep in mind that the mediation agreement allowed them to obtain a judgment if they wanted to. If they had actually gotten this agreement that they claimed they got from the county, they would have gone down to the judge and gotten that judgment and put it in public records so everyone knew about it. But for one reason or another, there's no judgment that was ever entered on this. I can confess that I'm old enough to know that in 2003, court files were paper. And they were destroyed under retention policies after, well, it's a civil case, 5 years. The lawyers would have done that. They're signing an agreement on paper knowing that in a few years it's going to be gone. And the concept that that agreement was going to be one that lasted forever after the law was changed makes no sense at all. So my position on the front end of this is that it does not mean what they claimed it meant and what the judge found, that you should issue an opinion that explains that in the context of this paragraph, it was 912 dwelling units because that was what the law was at that moment in time. If you make that holding, by the way, I don't know we need to go on to ultra-virus, but certainly if there needs parole evidence as to what they meant, if what they meant is what we've discussed with Judge Gannon, then it's clearly ultra-virus. You don't need to use parole evidence because there's nothing to go back to look at. So I will...
Counsel, for ease of reference, will you tell me, I know you're looking at the mediation agreement right there. Will you tell me what page of the record it is on, just so I can
So you
immediately
can do
grab
that,
it?
and I'm sure it's in my appendix as well.
It is.
But it says here, in the copy I have says 19 to 20. You know what? I'll give you that when I get
That's
out to
okay.
reply,
I thought
'cause
you
know
might have it. I thought it might be at the bottom of your
the
page.
appendix. I have the appendix site, but I don't have that.
What's the appendix site, Counsel?
Well, I'm looking at pages 20, 21, and 22
Thank you.
of the appendix.
That's great. Thank you.
And lastly, I ought to confess that I'm not a big fan of opinions written with alternate holdings. I think they make more trouble than not. But even if you reach the first issue, at least commenting that the second issue about ultra-hazardous is something you need concern is something I think we should do. So I'll reserve the rest of my time for rebuttal. Thank you very much.
Good morning, Your Honors. May it please the Court, I'm Steve Baranek of Baranek, Berman & Sider, representing the the appellee, the Cappuccino Civic Association. Judge Brownlee, to answer your question, the mediation agreement's in the record in a lot of places, but look
Yeah.
at pages 446 to 448.
Thank you.
So, Your Honors, excuse me, the county makes two arguments. First, that the settlement agreement doesn't mean what it says, and secondly, that even if it does, it's unenforceable. So let me first start with what the agreement says. I don't think there's anything remotely ambiguous about the limitation in the agreement. The first two key sentences say that the total number of dwelling units on South Seas Resort is limited to 912. No building permits may be issued for the dwelling units that will cause that number to be exceeded at any time. We're simply asking the court to enforce that plain language, and even the county concedes that the court has to review this agreement, giving supremacy to the text. Now, Lee County says that you should read that 912 limit to say that it's limited to 912 until the county decides to change the zoning.
But what about his point that it says the limit, and I'm trying to listen and pull it up immediately so I can quote it. He's saying it is 912. That's the current limit. And now we're tasked with figuring out how that number works with, this development, right? So what do we do about is 912? What happens when it is 5,000?
Well, there's three sentences. The first sentence says that the current limit's 912. The second sentence says that the county is not going to issue any building permits in excess of 912 at any time. That's a very strong, forward-looking phrase. The county certainly could have negotiated a provision that said it's limited to 912 until the county decides to change the zoning. They didn't do that. You'd have to add words to the agreement, which of course you're not allowed to do. But then we have the third sentence, which states that determination number 1 of the July 30th, 2002 administrative determination will control, and that determination number 1 is the determination that counts the units at 912 and is the basis for future development. Again, we have very strong language, very clear language, forward-looking language that suggests that 912 is going to be the limit for all time. Again, their argument is that you have to read that to say it's a limit of 912 until we decide to change the zoning, but they could have negotiated that, they could have put it in there, and it's not there. That's the fatal flaw in their argument.
Counsel, what if at the time this agreement was entered into, the ordinance at the time permitted 2,000 units, but the county entered into an agreement with CCA saying we'll never issue building permits beyond. Would that have been a legal agreement for the county to enter into? Because it takes the estoppel argument off the table if that was the state of affairs going into it, and so there's no reliance. It's just an agreement at a point in time when they'd be agreeing to issue fewer building permits than the existing ordinance allowed. Would that be legal?
I think you're getting at an important point, and a point that I like to emphasize strongly. That is not the case here. What this agreement did was enforce the status quo that had been in place since the 1973 approval for this development. This development was approved at the request of the developer for 912 units, and that was and the developer wanted those 912 units and could have had more, but said in exchange for the 912 limitation, we're going to do this in a different way. We're going to cluster those units, so we'll have some areas where there'll be high density, and then some areas where there'll be the empty land. That's what the county commission approved, and that's how that development was built, and that's how it was sold to all the folks that bought into that development. And so when the county in 2002 issues its administrative determination, suddenly it looks like the county, through this administrative process, is going to increase that 912 units. That's when the Civic Association filed that lawsuit and said, no, you can't exceed 912. To the extent that context is relevant, please take a look at the lawsuit, because you'll see that the 2002 lawsuit was very clear that its goal was to enforce that 912 density limitation, and the whole point of that lawsuit was that the county was playing around with that 912 unit limitation through this administrative process, which it shouldn't be doing.
But CCA would not have been able to sue and obtain that result unless the existing law already capped it at 912, correct?
Yeah, I think
It
you
couldn't have
have
just
to-
asked for that because it wanted it, or it had to have based that its lawsuit on the existing law at the time.
Yeah, and I think that's what separates this case from all of their arguments about this agreement being ultra vires or a violation of separation of powers. All this agreement did was enforce the existing status quo, which at that time had been in place for 30 some odd years, and now has been in place for 53 years, or at least until the 2003 zoning change, which is, how this kerfuffle all
Doesn't
started.
that cut against your argument, though? I guess I'm struggling to see why that doesn't hurt you. Like, if the entire lawsuit is just about interpreting the current ordinance, and now there's a new ordinance, doesn't that cut against your argument that they have the authority to bind, these entities on a new ordinance that's not even before them? Or that's not currently in place? I think it goes to Judge Gannam's point. Could they have violated the ordinance through a mediation agreement?
No,
Compound question.
yeah, and clearly they could not have violated that ordinance through a mediation agreement, because that would have been illegal contract zoning, but they certainly can confirm the status quo. Let me just give kind of a simple example. It's important to understand that this mediation agreement is enforceable precisely because it folds perfectly within the way this development was approved, built out, and sold. So now you fast forward, let's say in 2002, SSIR, or whoever was the developer at that time, let's say the county told SSIR that, sorry, even though you were approved for 912, we've decided we're going to change that to 700. SSIR would be the absolute first person in this courtroom arguing that it had a vested right to those 912 units, that a subsequent legislature could not take those units away. That's precisely the argument that we are making. Our folks bought into a development that was approved, conditioned upon this 912 unit limitation, and now the county, 50 years later, wants to take away those vested rights. And so that's when counsel talks about this being a mere contract. There's nothing, mere about a contract. The contracts in Florida have constitutional protections. Article 1, Section 10 of the Florida Constitution says that the legislature cannot interfere with a party's vested rights under a contract. So we're not talking about a mere contract here. We're talking about the constitutional rights of all of the folks first that signed this agreement that have the right to have it enforced, but then the right of all of the folks that bought into this development based on that 1973 condition that was at the request of the developer.
But don't they buy that knowing zoning ordinances can change, or is it your position that somehow they're all buying it, they're buying properties with knowing that this mediation agreement exists?
Does
that
that
has
go to
not
counsel's
reduced-
point about it being unrecorded?
Yeah.
But
It's not, they're not on notice, right? Because it's not in a judgment, it's not recorded.
what's different about this is that this is a limitation about a particular development. This is not a limitation that really applies to the land in Captiva. It applies to this particular development. So South Seas was approved at a 912 unit density. It was then conditioned on the 912 unit density. It was then built out. It's completely built out at that 912 unit density. So we think that the folks, just as SSIR has the vested right not to have the 912 units reduced, all of the other owners in this same development have exactly that same vested right not to have that 912 density unit increased. It's what makes this different from the other cases is the fact that this limitation is applied to a particular development that has already been approved, sold out, and developed.
Counsel, I think there's another difference, though, and that is in the cases that you cite, like the town of Largo and the city of Miami Beach v. Clevelander, those cases talk about the vested rights in the hands of a property owner who has gone through some process to get either approved development agreements or in other his has entered into certain transactions with the government that they're relying on, substantially relying on, and that have real value. Whereas you're representing an association that is alleged, I'm sure it's not disputed, that some members of the association own property. But even one of the cases you cite, the Town of Largo case, says the mere purchase of land does not create a right to rely on existing zoning. So might have individual landowners who bought land understanding that this is what the zoning says, but they didn't do the work of getting the development agreements approved or or all that. They don't enter into that same position as the vested rights holders in the cases that you cite. How would you get them to occupy that same status as, say, SSIR or another landowner who's actually gone through these processes to get government concessions and things that they can legitimately rely on?
Just step back a second. The right that we're enforcing is this contract right that was entered into in 2003. I'm making this point about the vested rights to address counsel's argument that there's something that's somehow unfair about this, what they term a forever limitation, or the tying in the hands of the government. All I'm saying is that there are all sorts of contracts and all sorts of situations where the government's hands are effectively tied. SSIR, as I said, would be the first to come into this court and argue that that the government's hands were tied forever in connection with their 912 unit limitation. So the point I'm making is not to ask for this court to rule that our clients had a vested right. What the point I'm making is to suggest that when you say that you can't have contracts that affect the government going forward over the long term, that's ultra virus. And the point I'm making is, no, there are all sorts of contracts that create all sorts of rights that tie the hands of the legislature going forward. So you have cases like the Childs case and the Gadsden case, where the Florida Supreme Court specifically says that it's not a violation of separation of powers just because a contract that one governmental entity enters into is going to tie the hands of a future legislature who can't interfere with that contract anymore. That's really nothing more than a recognition of Florida's constitutional protection for contract rights.
But are we different? Is it different because we're in a police power situation here where the county, if the legislature has this obligation to create these ordinances that make sense for particular barrier islands, which are unique, what if it went the wrong way? Like, isn't it sort of dangerous to allocate this power to someone else and take away their police power? So why I'm saying that is, what if hypothetically the situation was that they had contracted to always be able to have 912 you have to, for whatever reason, right, you have to have 912, and then they looked and they said, no, we've got to amend that ordinance. They have to have way fewer there because these barrier islands need to be protected. You could only have 500. And then your client came in and said, no, this agreement says we have to have 912. And the county said, that's really dangerous. I mean, it works better, right? Because now the ordinance allows you to increase, but wouldn't it be dangerous if it cut the other way?
I'm not sure if I'm following the sense of your question.
Okay. I'm concerned about taking away the police power, the zoning power, the power to decide how many units can be on something. I think that in certain situations, perhaps in this one, we say the max can be 912, everything might be fine. But if it went the other way and you said they have to have a minimum of that. I mean, I know that's like an extreme, why would that ever happen?
I think the difference is whether you're talking about this happening on the front end or the back end of the development. If this happened on the front end of the development and we were trying to enforce this contract before anything was built out, I think, and before it was approved, then I think you'd have a classic case of potentially illegal contract zoning. But this is taking place at the back end after the development has already been approved, after all of those considerations have already been, have been looked at by the county in terms of how much density should you allow on a barrier island like this, and the ordinance has been passed that has that specific limitation. When the agreement does nothing more than tie the government's hands to that status quo that is already existing on the back end, then you don't have any of the problems of this separation of powers or contract zoning. And
Counsel,
I think this
Can I ask you about contract zoning? Because we understand, I think everyone agrees that, for a county to make an agreement with a private party to enact a particular zoning ordinance, or not to change a zoning ordinance, that's considered illegitimate as contract zoning. And under the Hartnett case, that's based on I think a transcending principle that it's wrong for a municipality to contract away its police powers. Why wouldn't contract permitting be illegitimate for the same reasons that contract zoning is illegitimate?
Well, they say contracting away their police powers. I think this separation of powers argument is absolutely overblown, because if they're right, counties and governments can never enter into a contract. Every contract that you enter into ties the hands of the parties, and that's no less true for the government. If I'm a legislative entity and I enter into a 50-year contract with the Tampa Bay Rays to build a new stadium, well, there are all sorts of things for the next 50 years that the county or the city or the state or whoever enters into those agreements is not going to be able to do. Every agreement ties your hands going forward.
But doesn't the agreement have to be legal at the time it's made? And I think that's the problem here that we're struggling with is if we could determine that this agreement was not legal at the time it was made, and then all those other considerations are off the table. I mean, it has to be a legal agreement before any of these other principles come into play.
Absolutely. And so what are the arguments they have that it's an illegal agreement? First, they argue contract zoning. But I think it's absolutely clear, looking at the cases, that this has nothing to do with contract zoning. And in fact, in their brief at pages 39 to 40, they say, well, yeah, technically this isn't contract zoning, but you should treat it like contract zoning.
Well, that goes back to my question, why isn't contract permitting just as bad if what the county is doing is contracting away its ability to say, because contract zoning is bad because, zoning is supposed to be decided by the county in the exercise of its police power. And if they enter a contract, then the fix is in. They wouldn't subsequently exercise their independent judgment on whether to enter a zoning ordinance or not create a zoning ordinance. On the permitting side, I think it's even perhaps more problematic, because I think we've heard, maybe you disagree, that once a party who applies for a permit satisfies all the legal requirements for the issuance of that permit, then the municipality has no discretion to say, no, we're not going to give you one. But so how could it be okay to enter an agreement with a private party to say, hey, we're not going to give permits to people when they otherwise satisfy all the requirements for them?
Well, first, this distinction between zoning and a building permit, I mean, the building permit here is just the vehicle for enforcing the 912 unit limitation that was the condition upon which this development was approved. So I don't think the evil of contract zoning, what the cases all focus on, is that you do a deal that's completely outside of the process without going through all of the steps that you have to go through to determine whether the zoning is appropriate. Our point is that when you reach a deal like this after the fact that preserves the status quo, you are, in fact, it's the opposite of contract zoning, because you're confirming a process that has already been taken place. So you're not circumventing the process, you're affirming that process. And the building permits just happen to be the vehicle for affirming that process. So it's the combination of this agreement that was entered into with very plain language by the county voluntarily. So all this stuff about, taking away their police powers, this is an agreement that the county wanted to do. They wanted us to drop that lawsuit, and so they signed this paperwork. Nobody forced anything on them. So when you look at it that way, and you look at it preserving the status quo, there is simply no interference with any police powers. I remember it was the Gadsden case or the Childs case, but it specifically says the fact that you're arguing that this contract is going to somehow tie the hands of a future legislature is wrong. That does not violate the statute, a separation of powers. So for all of these reasons, we think the contract means what it says, and that it was perfectly enforceable. It goes back to how this development was approved and built out, and we think that this court should affirm.
You know, in 1972, all those property owners in the north end of Captiva Island, the status quo was that there was 3,900 dwelling units. And in 1973, the law changed and there were 914 dwelling units. I've heard the word status quo about 20 times in the last 20 minutes. The status quo was governed by the law. And what he is saying is that he wants to have the right to control the law for an indefinite period of time for a private association. And that's not a contract that they could have ever entered into. The discussion about, well, governments can do long-term contracts. They can do it for stadiums and things like that. Sure they can. But this is a police power. And the cases that you're citing that are so-called, contract zoning cases, what are they? There's someone who doesn't want to live with the status quo, wants to change it for their own, one piece of property. One owner says, for this project right now, I want to be outside the law. I want to be able to do it this way, and you can't change your mind about this after I start building. And those contracts, we've repeatedly said, are delegating police powers, and that they're not valid, enforceable contracts.
But do you agree that those are distinguishable cases, that the true contract zoning that we see in there, it's unlike, it's not a mirror, or it's not an exact match for what we have in this case. Do you concede that?
It's not an exact match because this is the extreme version of it. Here we have someone who is not even a property owner at all coming forward and saying, I want an agreement not just for one parcel, but for an entire zoning district. And I want an agreement that the status quo, which is the current law, is going to stay that way forever, that you can't change the law, that the next county commissioners that are elected can't change the law. That's what's going on here. So if it is ultra virus to do this for one property owner, for one lot, for one project, it's 1,000 times more unconstitutional to do it in this context for this private association, to give them these rights. And this is not a separation of powers issue, by the way. I have not argued that. There was some brief issue we argued below that was that. But we're not separating powers between three branches of government. We're giving control of the building department to a private association. And that's simply not legal. So unless this board has additional questions you'd like to ask me, I think I'm finished. Thank you very much for your time.
I want to thank both councils for their argument and their briefing in this case. The third case we're going to call this morning is George Santiago versus State of Florida. It's number 25-1003. So council, you may take your time getting set up. Counsel for the appellant, Mr. Santiago, whenever you're ready. Before we begin, how much time would you like to save for rebuttal, if any?
5 minutes. May it please the court. Good morning, Your Honors. Eric Cerise on behalf of the appellant, Mr. George Quinones Santiago. This court should reverse Mr. Santiago's judgment and sentence for the reasons stated in our initial and reply briefs. Although for purposes of oral argument today, I'd like to focus the majority of my time on issues 1 and 3 as labeled in the briefs. That is the trial court's ruling on the initial motion for judgment of acquittal after the close of the state's evidence. And the third issue being the trial court's evidentiary ruling that the door was open to otherwise inadmissible evidence. Taking the first issue, quite simply, the issue boils down to the state, in its charging document, charged a specific crime, that is trafficking in fentanyl. However, the state's evidence established an entirely different controlled substance.
Did the charging document need to specify that it was a derivative of fentanyl versus fentanyl? Did the charging document, I know it did that, I know it specified, but did it need to be that specific?
So, yes, Your Honor, in light of Section 893.135, which delineates the different controlled substances that the state can pursue in a charge like this, it's our position that when the state did delineate in its original information fentanyl or a mixture containing fentanyl, and specifically cited 893.03, I think it's B9.
2B9. Yeah.
2B9. There's a lot of statutory provisions in this argument, so bear with me. That they grounded their case, the state grounded its case in fentanyl. And as I'm sure the court is aware, the testimony as it was adduced at trial and the FDLE expert testified that parafluorofentanyl, which was the substance that was introduced or established at trial, is not the same as fentanyl or a fentanyl derivative. Now,
She does say that though, right? So the FDLE agent says, I don't have it in front of me, right? She says, this is a type of fentanyl. It has one more atom. It has like a fluorine, right, attached to it. And so then it becomes parafluorofentanyl. And she doesn't say, I don't know if she says derivative of fentanyl, but she has testimony in there saying it's fentanyl, okay? I think this statute is a little bit wonky in that, and when I say that, I mean 893135, I had it memorized, 1C4A, okay? It has under Roman numeral 3, which the state picked, fentanyl, okay? But then later, it characterizes all of these Roman numerals and says that if you have, right, one of those, a person who knowingly sells, purchases, manufactures, et cetera, 4 grams or more of one of these Roman numerals commits a felony of the first degree, which felony shall be known as trafficking in dangerous fentanyl or fentanyl analogs. So it's like, it's defined, fentanyl could be that, and then it would be trafficking in fentanyl, or one of the other ones would still be trafficking in fentanyl. The reason I'm asking you this is I'm not sure, do they just have to prove one of them, but they just have to prove fentanyl? And then the jury instructions will say 4 grams or more, knowing possession of fentanyl, and you could just pick one of those. It seems like fentanyl is the element and not one of those Roman numerals, if that makes any sense.
well, I think it does. I think what your question gets to, Judge Brownlee, is that when the state elects to specify a specific controlled substance, as it did in its original information, that it's required to prove it as charged. And there's a myriad of cases that stand for that proposition. The Morgan case, the JB case.
I think that, I mean, it's an easy call if it's cocaine and fentanyl, right? That's easier. I'm like, well, you just said cocaine. Now you've just described a different type of fentanyl, and I have an agent telling my trial court, or our trial court, right? She's saying it is a type of fentanyl. And then they're like, we just had to prove fentanyl. And he says JOA denied.
Sure. So a couple responses to that. And the first thing I'd like to kind of acknowledge with the court is that there appears to be this inclination to treat these controlled substances as one and the same. I think that's kind of, Judge, what your question is getting
Right,
at.
okay.
But in light of the statutory text and the way that the Florida legislature has delineated these different controlled substances, they're not the same. And I understand it's tricky when the substances that we're talking about, at least in part, share the same name, right? But the statute at issue, or the statutes at issue, delineate these controlled substances differently. One is a Schedule 1, the other is a Schedule 2.
And tell me why does that bear on sentencing, or is that bearing at all on the conviction? Like the scheduling, setting aside for a moment your argument that these two are different substances. I understand that's necessary to understand. But for purposes of the schedule, we've got fentanyl that has medical purposes, and then we have the derivative that does not, right? does that really just matter for sentencing purposes? Like, one, you get an increased sentence, or does the schedule matter for conviction?
I think it's the latter. At least in this instance, the sentencing scheme or the proposed, possible exposure or punishment was the same. So,
Okay.
So, yeah, right, it's a 7-year minimum mandatory for either. But I would point out that even in the sex offense cases where the state could charge one theory of a sex offense based on which body parts were touched or in which manner the sex offense took place, and if that is grounded in an information, then the state is required to prove it that way at trial. Regardless, though, of which body parts were touched or which way the sex offense was carried out, the punishment's the same. So I don't think the punishment necessarily is determinative in this context. I think it goes to the crime. The Florida legislature has chosen to delineate these substances separately. In fact, even in 893.03, they define a fentanyl derivative as excluding fentanyl. So while it might sound counterintuitive, fentanyl and perifluorofentanyl are different controlled substances.
Counsel, you just said something important I want to understand. I agree with you that the legislature has chosen to allocate these differently. They've delineated fentanyl and perifluorofentanyl in the Roman numerals. But what I heard you say is if they've chosen one in the information, that it has to be proven. It's not superfluous. Does that make it an element? And my other question is, if they hadn't put it in the information, if they had not delineated in the information, would we be here? If it had just been blank, if they had just said you are charged with violating 4A, and they hadn't gone out of their way to say subsection 3, fentanyl.
So the short answers to both of those questions, Judge, is yes to the first and no to the second.
Is the first yes because of prejudice, or is there a legal reason besides prejudice that they have to prove it?
Well, the first is that I'm not sure I understand. So the first question you asked was, is this an essential element to the crime?
Correct. Sorry.
Our position is that it is.
Okay.
And I think that's supported by the jury instructions, which require the state to establish that this substance is, after the amendment of the charge here, in this case, a fentanyl derivative. Originally, it would have been fentanyl. And not only that, I think the jury instructions on the lesser included offenses substantiate this argument. So under the original information, it would have been simple possession of fentanyl. That changed after the mid-trial amendment, and now it's simple possession of a fentanyl derivative. So I do think it's an element of the crime.
But I'm not sure the prosecutor had to charge it that way. I mean, I think when he goes back, and I don't know, I mean, I appreciate that this is speculation, but he goes back and charges it under the same statute, right? And then does, 1C4A, and then says a fentanyl derivative. I mean, if you're going to, I don't know, I just think that's a highly specific. I think you're like typically looking at these informations and saying trafficking in fentanyl, and then all of these count. But I don't want to interrupt your answer to Judge Nardella's important question.
No, I think it's somewhat related. I think the fact that the state elected to specifically ground this criminal offense in 2B9, specifically mentioning fentanyl or a mixture containing fentanyl, they boxed themselves in on that criminal offense. It's the same thing in the context of the resisting cases. If the state charged resisting arrest against Officer A, but the evidence at trial was that the resisting was against Officer B, then the state hasn't proved the crime as charged.
But if you change the address of the location that was robbed, it's no harm, no foul, right?
Sure, but that's because it doesn't substantially prejudice the defendant.
Well, that's what I'm saying is I think these things are really case specific and unique. So when you're going, if you guys are all going to trial and you're going to build the jury instructions and you're having the charge conference for the judge, and we all know that, like I would always pull it from the Florida Bar's website, and it says insert specific controlled substance, and you're going to map out your jury instructions for the judge and say, I've got a trafficking and fentanyl case. What does that look like? Say they picked perifluorofentanyl correctly the first time, they say fentanyl derivative. Are you guys going to build those jury instructions where it says enter controlled substance, and you're going to put 4 grams or more possession of perifluorofentanyl, or are y'all going to put fentanyl?
Well, I think in this instance, that's kind of what happened, right?
I
So
know,
that-
I just think, is that what always happens? I mean, I think when he amended that information, he got really specific with it. I don't know whether that was necessary or not, and I think whether it's necessary is the key thing in this case.
Sure. And I recognize that some of the sub-issues under this JOA argument only become relevant if the court accepts our premise that it was charged incorrectly and the state's evidence didn't support that specific charge. But Your Honor, the jury instructions did in fact start with fentanyl. And the state's mid-trial amendment to conform to the evidence of a separate and distinct, as the FDLE analyst described it, a different controlled substance, that just goes to show that there is a difference between these controlled substances and that the state felt it necessary, in our view, and as our briefs describe it, almost an implicit concession, that it had to amend its information to conform to the evidence because those controlled substances were different.
All right, what about how the jury instructions say, 4 grams or more, whatever it says, and then of a fentanyl derivative, and then they instruct the jury, right, as a matter of law, parafluorofentanyl is a fentanyl derivative. So wouldn't it be, couldn't you envision another case where you say, all right, state alleged parafluorofentanyl, and we're going to instruct them on parafluorofentanyl, and then you say 4 grams or more possession of fentanyl, and then this jury heard parafluorofentanyl all the time. So you say, just like they did in this case, parafluorofentanyl is a type of fentanyl. But wouldn't that take care of it? And it's not really an element. You're helping them with the case and the manner in which the state proved it.
Judge, I think I would have to fall back on the way in which the legislature has delineated these different controlled substances.
I know, but then the legislature swoops them all in. I'm hogging this oral argument, judges. It swoops them all in at the end and says, if you do any of those, you're trafficking in fentanyl or fentanyl analogs. And in fact seems to be so unconcerned about the specifics that in Roman numeral 6 and 7, it's sort of broad. It's like a controlled substance analog of any substance described, a mixture containing any substance. So it's like, these are all trafficking in fentanyl. It feels like that's the point, but I'm troubled that the state put this in the information, then didn't prove it.
I think that's the gist of this argument, Your Honor, is that, and it goes back to Judge Nardella, what you mentioned, is would we be here if the original charging document didn't specify a specific controlled substance, fentanyl? I frankly don't think we would.
Counsel, can I ask you this is sort of an order of operations question. Assume that we agreed with you that the state failed to prove an essential element at trial and that you would have been entitled to the judgment of acquittal. But the state says, like in the Thatch Supreme Court case, like, yep, we think that the defense has a point. We're going to amend our information to include the thing that we did prove. And then we enter into a different analysis, which is the mid-trial amendment is permissible unless it prejudices the defendant. So do we have to reach the question of whether you would have been entitled to the JOA, or do we now have to focus on the amendment because the trial court granted it, rightly or wrongly, and just answer the question whether it was right or wrong to grant the amendment? In other words, which issue do we have to decide, or are they so tied together that we still have to decide both?
No, I think the court only has to turn to the prejudice of the mid-trial amendment if the court agrees with us that the state charged substance A but only proved substance B, because then that question becomes relevant, Your Honor. A mid-trial amendment to conform to the evidence is only permissible if it does not prejudice the defendant. And in this record, I think there's little argument from the state that there was any prejudice, was not any prejudice. The trial counsel below went as far as to swear himself in and essentially proffer the prejudice that occurred in this case.
And is that prejudice is tied 100% to the speedy trial issue, correct? Well, let me back up, and I'll let you correct me if I'm wrong. A decision was made to not waive speedy trial,
Right.
with the understanding that, we've seen the discovery. It looks like all they're going to be able to prove is parafluorofentanyl. They've charged him with fentanyl. Let's go to trial, put them to their evidence, and assuming they prove what we think they're going to prove, we win. Whereas if that decision hadn't been made, you could have waived speedy trial. You could have called this to the attention of the prosecution. You could have done other things and really worked up the case to defend against parafluorofentanyl. But a decision was made not to do that.
You're right. strategic decision to proceed based on how we would describe it, a charging defect. So once he sees what he's charged with, this is the trial lawyer. Once the trial lawyer understands what the defendant is charged with, and then in the discovery sees it's a completely different substance, it's a strategic decision to move forward.
But that's strategy, right? That doesn't bear
Sure.
on a defense that's chosen. Like, it becomes problematic, I would think, if you've, and the cases talk about this, like, well, what would have changed about the defense? This is just putting all your eggs in one basket, right? And I get it. But, you know, when you look at like prejudice cases, it's, well, I have an alibi defense. And you said that I robbed the bank on January 23rd. And so I developed my alibi for January 23rd. And now you've changed it. And my alibi defense goes away. And now you've picked a new date. And I don't have any defense to that. Like, there's no defense. It's just putting all your eggs in one basket.
So I would agree in part, Judge, that at least in this case, the defense was entirely centered around the difference in the substances. But I think procedurally, there's a lot of prejudice here, too, that the court should consider. That being that the defendant invoked speedy and filed a notice of expiration to effectuate that timeline. Not only that, as the trial lawyer testified to below, he elected not to pursue certain pretrial actions. So there was no depositions taken. There were no plea negotiations. There were
But
no
I mean,
motions to
that's a
suppress.
huge risk, and it was a knowing risk, right? And does
Sure.
that matter? I mean, in the case law, having notice seemed, so he knew it's a risk. And he's, you know, you could have said, we got to get some of these depots done. We didn't waive speedy. Hey, Judge, I'd like 5 minutes to go depose the guy. Whatever it is, he knows that he's got the problem and then doesn't do anything.
Well, I'm going to mention I'm
Yeah,
quite,
counsel,
quite a
keep
bit
going.
into my
I'm sorry. Go
rebuttal
ahead.
time, and I'll do my best to.
Well,
Yes, Judge?
I will give you back 2 more minutes in your rebuttal time if you want to answer Judge Brownlee's question, and I'll credit the state the same. So go ahead.
So, Judge, I understand the court's point. However, I think the starting question is, how did the state put the defendant on notice of what charge he was supposed to defend against? And when the state explicitly said, we're going to charge you with trafficking in fentanyl, and the discovery shows that that's not what the state's going to be able to establish, and the legislative structure of the statute as well as the FDLE testimony supports that, the amendment mid-trial is the equivalent of dismissing the first charge and adding a completely new charge. And in light of the speedy trial context that we were playing in here, the appropriate remedy was to either grant a judgment of acquittal on the front end or to discharge the case after the amendment. I hope I did a decent job of answering that question for you, Judge Brownlee, but I'll reserve my time for the remainder of what rebuttal.
Good morning, may it please the court. My name is Roberts Bradford. I represent the state of Florida.
Hold on one second, Mr. Bradford. Marshall, I'm trying to add 2 more minutes, and it's not going for me well. Whenever you're ready, counsel.
Thank you. The general rule here concerning mid-trial amendments is that the state may do so at any time unless there is prejudice to the substantial rights of the defendant. That's not just simple prejudice. Everything the state does prejudices the defendant. That's the whole point. The unfair prejudice, it's a due process type of prejudice, an unfair prejudice, I would suggest. The Thatch Court talks about the importance of not only recognizing and safeguarding a defendant's rights, but also when the court is looking at it, to ensure the prompt and efficient administration of justice. So it's not just the safeguard of the defendant's rights. And it is, on review, a totality of the circumstances. You have to look at the entire picture, the entire trial, everything up to that point. And I think that's why this argument, this appeal this judgment should be affirmed. The court recognized below that the defense had the FDLE report, I think it was 2 months before, at least 2 months before trial. Plenty of time. They could have filed a C4 motion to dismiss, but they didn't. And they didn't do that because it would have put the state on notice so that they would have made an amendment pre-trial.
Is that the defense's obligation to call the state's attention to a defect in the charging document?
Absolutely not. No, it is not.
And should we count it against them that they didn't do that, but that they elected to put the state to its proof and go to trial.
I think you should count it in the sense of your consideration of the prejudice to the defense. As my learned friend acknowledged up here on before, this was a tactical decision. They saw the error compared to the information, and they just kept quiet, and they were going to ambush after trial started, after jeopardy had attacked.
But I mean, it's a huge catch-22, right? If we hold that against them now, and I understand, I mean, I think that the case law really says, like, notice is a big deal here. I also think speedy's a big deal here, right? So they make this, like, huge strategy decision. But I mean, if you're that defense counsel, you're like, state said X, I'm going to trial on X this whole time, and you're like, you guys, they haven't noticed it. You'd probably be the worst defense counsel in the world if you were like, hey, state, you need to charge him with the Schedule 1 instead of the Schedule 2, or whatever, right? I mean, he's going to bring that to his attention?
No, I wouldn't
Maybe he needs
expect
a
him to.
backup plan.
When I did defense work, I certainly didn't bring stuff like that to their attention. You keep that in your back pocket. But at the same time, you have to prepare a plan B, because you know as soon as you get in there, they can amend the information.
Did they amend
Right
the
after the jury was
information
sworn.
too late? I mean, he moved for a JOA. The state still didn't ask to amend the information. Like, it's not contemporaneous. At first, I thought it was contemporaneous. The JOA, or excuse me,
Right.
the amendment happens like with the judicial notice stuff.
Yes.
What is my timing like there? I mean,
The JOA, and I think this goes back to the point you were making earlier, that the Barrington, the FDLA experts, said it is a type of fentanyl. It is a fentanyl. And if you look at that factors in as well, because he was charged under the trafficking statute in the original complaint. He was charged under the trafficking statute in the amended complaint, 1C4A. Now, 1C4A is the fentanyl section of the trafficking statute. Starts off with cannabis, goes to cocaine, goes to whatever else. I think oxycodone is in there, the opiates, the methamphetamine. This section is the fentanyl section, and it includes all those different chemical constructs, and that's what the court ultimately said and found with respect to the amendment, is that you knew that that's what they were talking about, this fentanyl section. And so
but it's not what they charge, right? And so I think this goes back to Judge Ganem's point, which was, to Mr. Soris, which was, what's our timing like here? Like, if we just, I had a crim pro professor in law school that was like, freeze frame. Where are we now? Where are we now? Where are we now? When he first moves for JOA, there's no effort to amend the information. So
Correct.
your position on that, is your sole response the FDLE agent's testimony? And I agree with you, that's what Judge Kranick said. The FDLE agent's testimony gets you past JOA because she said it's a type of fentanyl, has an extra atom.
in a light most favorable to the state, it is a fentanyl, is what was alleged in the original complaint. That's it.
Is that somewhat of a legal conclusion? So we have Ms. Barrington up there, and she can testify as to the chemical composition of these different substances, correct? But the statute, I think Mr. Reese's point is, the statute tells me that these things are different.
They are all different in the sense that they, and this is the convergence of law and science, in the fact that it has an extra fluorine atom. There is a different chemical construct. However, all of these chemical constructs are included within this subsection of the trafficking statute. It even includes fentanyl analogs, which he was originally charged with. He was originally arrested for the possession of fentanyl analogs, if you look at the original charging complaint. That's included, and analogs, as I noticed in the brief, are these new designer kind of drugs where you alter the chemical construct to get around so you can still get the same effect and you can still sell it as a drug, but then you're not violating the law because it has an extra fluorine atom. So the analogs, and essentially what that does is that information gives them a short and plain statement as it's required to do. It identifies the statute under which he's being prosecuted. It identifies the minimum mandatory that's applicable to whether it is a Schedule 1, Schedule 2 fentanyl. It doesn't matter what type of fentanyl it is. It is a fentanyl.
Then why did they put it in there? Why does the legislature, they could just do they could do some broad statement, but they're delineating these. And the state, once the state puts it on notice, once the state says, you robbed, SunTrust and not Bank of America. Like, once the state starts putting these particulars in there.
If I may, Your Honor, the Green case talks about the fact that there's a whole line of cases. I was just looking for the original quote. Here it is. The common thread in this line of cases, the ones that allow amendments, is the amendment is permissible when it merely clarifies some detail of the existing charge and could not reasonably have caused the defendant significant prejudice. He was arrested for the possession of fentanyl analogs. He was ultimately charged with trafficking in fentanyl. But again, the change from the original information to the amended information wasn't different except for the type of chemical that was there, but it was still within the same subsection. And I think the importance of that is there's that line of cases that the Green Court was talking about, whereas ones where it's clear from the discovery, he's on notice, he's clear from the discovery that we're all talking about the same thing. So in those battery on law enforcement officer cases where there's a whole bunch of officers involved and the state chooses these two, but then mid-trial chooses and goes with another one, that's different because you got all these different officers. But there was one case, I think it was Taylor versus State, that said if you've only got one officer involved and everybody knows who you're talking about, it's a typo. And if it's a typo, then you can change it and there's no prejudice to the substantial rights of the defendant.
So then it must be your point, because none of that relates to elements of the crime, right? I had to think about that, but I think I'm right about that.
You're right. I think you're right because you talked earlier about the substance being inserted into the jury instructions.
Okay.
It says it would be fentanyl derivative or fentanyl, or they're on notice that they're being charged under that section of the statute, and then discovery. Let's say they were being charged with possession of or trafficking in analogs, fentanyl analogs. They're not going to know until the FDLA expert is deposed or provides a report. They're not going to know what that substance is. It's flushed out during the discovery.
But the state could have amended its information at the same time that the defense became aware that it was parafluorofentanyl that you're talking about. The state could have amended its information then too, correct?
I have to concede that, yes.
So what if in this case we had a charging document that said trafficking in cocaine, and the discovery showed it was parafluorofentanyl, and the same motion for JOA is made, the same motion for amendment of the information is made. Would this case be different? Because it seems like it would be, because cocaine and parafluorofentanyl just aren't the same thing. No, there'd be no testimony that they were even close to the same thing. Would the state in that case have to concede? Yeah, we didn't.
They would have to
prove
bring
what we charged.
charges under a different portion of the trafficking statute. Now you're getting into the substantial rights of the defendant.
But it's all the same statute. So you have if this is all under cannabis, cocaine, fentanyl is all under subsection 1. Then you start drilling down into the paragraphs and the subparagraphs and the subparagraphs. At what level of specificity do we cross the line where it would be impermissible? Would we have to conclude necessarily that the state just failed to prove what was charged, as opposed to here where you're saying, well, the state didn't really fail to prove what was charged. We got close enough because they're in the same subparagraph. I mean, at what point do we cross that line to where it's okay and it's not okay?
I think you have to go back to the general rule that the state can amend its charging document at any time, even mid-trial, unless there is prejudice to the substantial rights of the defendant. And in the line of cases, there's some where they added a charge of purchase of cocaine to an existing charge of possession of cocaine. That's a whole new charge. That's got to affect your defense, but not in a substantial way that you weren't already on notice of, because the facts of that case were he possessed it when he purchased it from an undercover police officer.
But what if we have a situation like here, say there was a permissible, and I know what case you're talking about, but say there's a permissible substantive amendment, but a prior JOA. Like, it goes back to my freeze frame question that I think is related to Judge Yannam's initial question, which is, wasn't he just entitled to a JOA at that point? And I didn't have an ASA who said, fine, if he's going to get a JOA, I want to amend my information.
Well, that goes back to the quality of the game of gotcha that he wanted to engage in, which honestly, in this case, probably would have been pretty good up until the point that the FDLA expert said it's a fentanyl.
When you go to prepare the jury instructions, do you put fentanyl derivative or fentanyl? Do you put carfentanil? I'm learning a lot that I didn't know this,
Yeah.
but would you put that in the jury instructions, or you put fentanyl as the element, and then you say, as a matter of law, to Judge Nardella's question, carfentanil is a type of fentanyl to help the jury because they've heard a lot about carfentanil.
I think you would put generally my experience has been you track the language of the statute, you would have put fentanyl derivative, and you would have had your expert testify that that is a fentanyl derivative.
And you would put fentanyl derivative. That makes me feel like it's an element. That's what the ASA did in this case.
It's an element, but again, the statute didn't change. The essential element didn't change in the sense that you're still under the same subsection. You're still dealing with all these different types of fentanyls. You're still on notice 60 days before trial that it was Schedule 1, not Schedule 2. And you just want to play gotcha. His defense to the merits did not change. Not once. Not a bit. He said, I took the xylazine, which is a Schedule 1, by the way, that he didn't have a prescription for. I take xylazine for pain. Okay, well, xylazine had already been brought up, so in regards to opening the door, that didn't do it. But when he was asked about the white powder being in, I'm sorry, I'm getting off track. The defense was, I didn't know it was anything but xylazine. So whether it was parafluorofentanyl, a fentanyl derivative, fentanyl analog, fentanyl itself, doesn't matter. His defense was the same. Now he wants to play, he's saying he was only prejudiced because he didn't get to play gotcha. But he knew going in, gotcha might not work. So that's not a substantial impairment of his rights.
What if we disagree? What if we disagree with you about the testimony of maybe Agent Barrier or Barrington? Thank you, Judge Nardella.
Barrington.
So if it is a question of law as to whether this constituted fentanyl, then, she can't just make that determination, right? So what if we think that her testimony can't clear that JOA? We're like, that wasn't enough. That's a question of law. She can't, rectify this problem. Can you still get around the JOA?
What evidence do you have to contradict hers?
Well, whether it's a question of law.
So you think the judge can overrule the expert testimony?
I think that the judge decides, she can testify to things,
Well, the
sure.
judge has to take the evidence in the light most favorable to the state for the JOA.
I understand that, but the judge is still going to decide questions of law, right? That's not going to be a factual determination for an expert.
It's a question of law. Whether it is fentanyl, I believe, is a question of fact.
But
I think
whether-
Judge Nardella, yeah, go ahead.
But
Judge
whether
Bailey, you can help me.
fentanyl is the same thing as parafluorofentanyl is a question of law so far as they're differentiated in the statutes.
How they're treated under the statute, yes.
Okay,
This again goes back to the convergence of law and science, but the evidence before the court was it is a type of fentanyl. If it's a type of fentanyl, then the state made its sufficient showing under the first information and survives the JOA. Then it chooses to amend it. Sure, okay.
well, if they choose to amend it, yeah, I guess my question is that I think I've asked it many different ways, so I'm not being clear about this. Is there a way under Florida law where if he was entitled to a JOA, say the court hypothetically gets it wrong, just gets it wrong, they go, right, which would be Mr. Soris's point, is it cleaned up by a subsequent cleaning up of the charge? Like, is it harmless once it's sort of cured on the back end by the state? Or is that a timing problem for the state?
Maybe I misunderstood the question. If the JOA is granted, trial's
No.
over.
Right. Yes. Then we
Yeah.
wouldn't be here at all. I'm saying denied, right? I'm saying you wouldn't agree with this, right? But say if the trial court denied erroneously the JOA, but then cleans it up. It should have been granted, but then whatever happens, it's kind of cured on the back end. Now is the whole thing
Oh, I
cured?
see, I see, I see.
Or are we freeze framing where that error happened, they should have walked out of that courtroom? Can you cure that? If you don't know, you don't know. I just thought I would ask, since I have you here.
I can't say for certain as far as I've read a case on that, or I remember an instance in dealing with that in a trial court. A lot of times they get into it in the discussion, and they kind of move to amend during the discussion.
Yeah.
And I see what you're saying here afterwards. I don't think so, Your Honor. I think, well, I mean, we can speculate in terms of what ifs, but the bottom line is that the expert said it's a type of fentanyl. And so the question of whether you survive the JOA, I think, is foreclosed. You do, because you have to take it in a light most favorable to the state. If it's a type of fentanyl, and fentanyl was alleged, that's good. With respect to issue number 3, which I assume my learned friend is going to address on his rebuttal, the state tried a couple of times to get in these other drugs, and the trial judge shut them down very quickly. They tried pretrial, didn't work. They wanted to get the crack cocaine in. Then before the cross-examination started, the prosecutor approached the bench. I want to get into it now. Is that okay? Nope, still haven't opened the door yet, because, and I don't think the trial judge got into it this far. She just said he hadn't opened the door yet. Because the only thing he brought up on direct examination was the xylazine, which had already been discussed by the FDA expert. But then he said that he used it for a scoliosis, and he was asked, do you go to the doctor about the scoliosis? And he goes, no, I usually just smoke pot or take drugs. And there was an admission he didn't have a prescription for what was in the pill bottle, and then you had the white powder in the pill bottle. Well, yeah, and some Xanax too. Now he's thrown in cannabis. Now he's thrown in alprazolam or Xanax, whatever you want to call it. He did that on his own. He opened the door. I think that's pretty clear. And then the state approached the bench again, made another motion. Yep, everything's fair game at this point. And he admits that he takes crack cocaine, Xanax, xylazine, and cannabis, at least, for his anxiety, for his scoliosis, so that he can work. That was his defense. He still made the same defense, whether it was parafluorofentanyl or whether it was fentanyl. The substantial rights of the defendant were not affected. Unless the court has any additional questions, I'll rely on my brief for the remainder of the argument and ask this court to affirm the judgment in all respects.
Whenever you're ready, Counsel.
Sure. May it please the court, just a few points on rebuttal, and in light of the court's apparent curiosity on the first issue, I'm going to spend my 3.5 minutes on just that first issue. So the first thing I would point out is this idea that the defense was on notice. I consider that to be a red herring. I think that's the whole point of this argument, is that the first thing that the defendant learned is that he was charged with trafficking in fentanyl specifically, as specifically cited in the information. So the fact that the defense subsequently learns through discovery that the controlled substance is not what was charged does not mean that he wasn't prejudiced, or it doesn't mean that that precludes him from seeking a JOA or a discharge after the mid-trial amendment. The whole idea was the state incorrectly charged the crime. There was a charging defect in the jury, or in the charging document, and it's not the defendant's responsibility to bring that to the light of the state.
But did they know the defense knew as of December 4th, 2023, when they received that report, that it was parafluorofentanyl and not as charged?
Correct.
I mean, I think with regard to notice, I think you're right. I mean, there's a problem with the charging document. However, to me, the point of notice is your ability to prepare the defense. is to get those bench notes from the FDLE, to do all of these things and to actually be able to prepare. Whereas if the state switches it mid-trial, and they take away your alibi defense, for example, you have no way to prepare. We got a due process problem here. But y'all knew, not you, right? The defense team knew over a month prior to trial, and then built their case this way. So they knew and consciously made decisions that I get, and did that. So to me, they're on note. I at least think they're on notice.
So, yes, Judge Brownlee, although I think the proper inquiry is to hold the state accountable for how it charged the crime. And so when they ground the criminal charge in subparagraph 9, which specifically delineates fentanyl, and then the defense builds its case around that, I think the more appropriate inquiry is to hold the state, and that's what the case law says, is to hold the state accountable for how they charge the offense. And subsequently, when we're at trial, the evidence has to conform to that.
Counsel, this prejudice issue, maybe the question is like, from what perspective do we consider prejudice? Is it always reasonable for the defendant to rely on the charging document in building the defense, such that even, irrespective of what evidence shows up in discovery, the defendant can build the defense on the charging document and then argue prejudice if the state tries to change the charge midstream? Or is the prejudice looked at from the perspective of, did you know what was coming? In other words, once you saw the discovery, even though you knew of the defect in the charging document, you had to be prepared for the fact the state would do this thing that's not that unusual of amending the information mid-trial. From what perspective do we look at or try to measure that prejudice? I think in the Holland case out of the first DCA, there was a question to the defense counsel was, well, what would you have done differently had you known about this? And in that case, the defense counsel said, no, nothing. And so later on, the court concluded, well, we don't think there was any prejudice. But is it really just a matter of the defendant choosing how to defend the case based on the charging document, and that sort of locks in the prejudice inquiry based on that perspective?
We would argue, yes, that it's the former inquiry that you described, Judge Ganim. I think in an instance like this, when I say I'm over my time, if I may, in an instance like this where the state explicitly lets the defendant know in its charging document that it's giving him notice of a particular controlled substance that's being trafficked, I think the prejudice, even subsequently learning that there's going to be a different controlled substance that's coming in at trial, I think the prejudice is the defense relied on the specific charging document, prepared an entire defense based on that specific charge, and then as the trial counsel described it below, the rug was completely pulled from underneath him after he moves for JOA, after he brings the evidence issue or the defect to the court's attention, to the state's attention. The state subsequently amends the information to conform with the evidence. I don't see any other clearer example of acknowledging the defect and the evidence problem here. And so for those reasons.
And one more question, counsel.
Yes.
So what is your best point to the state's position that, well, he had to deny the JOA because the FDLE agent got on the stand and said it's fentanyl?
Well, I think the court was touching on it. I think you have, on the one hand, the FDLE expert testifies that they're separate and distinct. She actually explicitly says on cross-examination that parafluorofentanyl is not fentanyl. On the other hand...
Because it has like one extra atom, but then she says it's a type of fentanyl.
Sure, but I'd go back to the Florida legislature's delineation of these. They exclude fentanyl from being a fentanyl derivative. So to answer your question as most directly as I can, Judge Brownlee, I think it's a question of law. And I think if this court determines that, even in light of the expert testimony, we have a statute that delineates these controlled substances differently. If the state did not, if the state proved one controlled substance but didn't admit evidence of that substance, then I think the JOA should have still been granted, and I think that this court can make that determination law.
Counsel, what do you do? So they do delineate it, you're right, and we've talked ad nauseum about that, but then they go on to say that if you do these things and you have these substances, it shall be known as trafficking in dangerous fentanyl, that catch-all.
Sure, and I think, Judge Brownlee, this might have been your first question right out of the gate.
I'm troubled.
Sure. I acknowledge that particular provision. I think it does add a wrinkle to this entire argument, although I would stand on the notion that the legislature did not lump all these controlled substances in together. I understand that there's a provision that says this is what we're going to call this crime, but I think the more pertinent statutory provisions for this court to grapple with is that subparagraph 62 versus subparagraph 9 in 893.03. And so because they're delineated separately, given different definitions, and have different chemical and legal constructs, the judgment of acquittal should have been granted at the outset. Barring any additional questions from the court, we'd ask the court to reverse and remand with instructions to dismiss this case. Thank you, Your Honor.
I want to thank both counsels for their argument and their briefing today. We have one final case this morning. Take your time packing up and setting up. The final case I'll go ahead and just call is Security National Insurance Company versus Jerry Mitchell as personal representative of the estate of Destiny France, and Mark Smith as Mounts, Judy L. Mounts and Destiny P. France, and Mark P. Smith as personal representative of the estate of Maggie Laura. The number of that case is 24-2035. So counsel, take your time in setting up. Counsel for appellant, how much time would you like for rebuttal?
I know that there's a cross appeal, but I'm going to argue things that relate to that up front, so I think I'll save 4 minutes for rebuttal.
Whenever you're ready, counsel.
May it please the court, I'm still Chris Altenbrink, and my partner Eleanor Sills is still unavailable to attend this oral argument. But together we represent Security National Insurance Company in this case. It's important to appreciate in this case, I'm not going to go through the sad facts of this case because I think you understand them, but it's important to appreciate in this case that when the trial started in the declaratory action case, the dispositive issue for which the three estates had the burden of proof was whether Maggie Laura, not her brother Antonio, was an insured under the automobile liability section of the Security National Insurance policy that was issued on her brother's car. The liability section of this policy, and most policies, says that a person is insured because if they're legally responsible for an accident. That's why we have the liability section of the policy. Since Maggie Laura was neither the owner nor a resident relative in the owner's home, she ends up being covered by a portion of the policy that's in virtually all family auto policies, been there for years, that provides that she is an insured with respect to an accident arising out of that person's maintenance or use of your covered auto with your express and implied permission. The lawyers for the three estates have known all along that the only way that Maggie Laura could be insured under this policy would be if she was legally responsible for an accident by giving the car to Mr. Cruz. That is exactly what they alleged in each of the underlying lawsuits that caused this DEC action to be filed. That Antonio Lara gave this car to his sister Maggie, and Maggie gave it to Mr. Cruz. But proving that theory under the facts as described here, with everyone dead and all these problems, proving that it arose that she had express or implied consent is a huge task for whoever has the burden of proof. And as a result, rather early on, the lawyers for the three estates basically shifted to a theory that conflates the supposed liability of Maggie Laura with the actual liability of Antonio Laura as the owner under the dangerous instrumentality doctrine that also makes his insurance company have coverage for him, and by the way, a duty to defend the actual driver at the end of any bailment chain. They confused that with the liability for her and whether she needed to be and was covered by the Security National Insurance policy. They did this and they continue to do this all the way through here. The reply brief that's filed in the cross appeal, heading on the argument is Security National issued the policy covering those with implied permission, in quotes, which means any user after the owner has consented to his vehicle being used beyond his immediate control. I'm sorry, but that's not a definition of implied permission. That's been the test since the first bailment cases under the dangerous instrumentality doctrine, provided that once the owner gives it to anyone as a user, that until we get to someone who's a full-blown thief, he's on the ride to be liable for whoever's driving the vehicle. And as a result, his insurance company now is also always going to put that in the policy as a form of liability for there. So this is totally conflating one version of this for the other, and it was done so that they wouldn't have to prove up that, that they had proof that Maggie was someone who had been received enough information from her brother that she could reasonably believe that he was implying that she could use this car even though she didn't have a driver's license, even though she knew she had a drug problem, even though that she had been stopped earlier supposedly driving this car without a license. We don't really know for sure whether the person who picked her up was his brother in Okeechobee County or whether it was him. But without all regard to that, they went on this whole mission to make it as if as long as he had given the car away, that was the end of this case. And that's simply not what the law is on this.
Counsel,
Yes.
the older cases on dangerous instrumentality and interpreting insurance contracts seem to focus on, say, you had in the old days a rental car company that puts something in its contract that tries to limit use so that they can then claim, well, we didn't give our permission to this downstream person.
Yeah.
And the
Yeah.
case law generally says we have to interpret these insurance policies or we have to interpret this contract language in light of the dangerous instrumentality doctrine and the policy behind it. We're not going to let an owner off the hook through
Right.
contract language.
Right.
Does any of that case law apply to our interpretation of the provision at issue here, which asks whether there was express or implied permission for that person's use of the car, that person meaning Maggie Laura in this case? I mean, do those dangerous instrumentality cases matter at all in interpreting this provision we're looking at?
I think the simple answer to that is no, but they successfully confused the trial judge about this entirely in this case.
So we're just looking at the plain language of the agreement and interpreting that?
Right. The dangerous instrumentality, which I've had to deal with for about 45 years of my life, was designed so that the owner was on the hook, and that meant right away that the policy had to protect whoever was hurt, no matter who was driving. But it didn't ever say, but you can't have omnibus insureds who were conditional insureds only if they had the permission implied or express of the owner to drive the car, which is what we have here. And so all of these cases they cite, if you read through them carefully, don't really deal with that. In Chambers, for example, in Chambers versus Chandler, I'm sorry, if you look at the facts and read it through, the person that was in the chain that would be just like Maggie wasn't even a party to the lawsuit. They were just suing the driver and the company, and this was one of your fights about the rental car agreement. It's not similar at all. And so the law has never required the driver's car to actually insure someone who was driving it without his implied consent. But the dangerous instrumentality doctrine has left the driver and the insurance company on the hook for the final driver over there. The people in between normally aren't sued because They're not insured under that policy, and it's, I don't know whether their own policies would or not. But those cases are different. And, you know, they didn't discuss it in great detail, but you go to way back to Ray versus Earl, the case from the Second District in 1973, emphasizing, well, he was a passenger. The facts of that case are that Mr. Earl was the plaintiff. He had been given the car by Mr. Ray. He was an express permittee, the first bailee in this chain. And he in turn gave it to a third person who got in an accident while Mr. Earl was a passenger, and he got hurt, and so he sued that driver. And the owner's insurance company was still insuring this because of the dangerous instrumentality and because Mr. Ray had given it to Mr. Earl in his capacity as the first permissive user of this vehicle, if you will. And so what this case held was the carrier for Mr. Ray, who pays on behalf of ultimately the final driver, is not entitled to indemnification from Mr. Earl's insurance company. They settled with Mr. Earl, and then they turned around and tried to get the money back from his own insurance company, and the Second District said no. But that has little or nothing to do with the circumstances we have here. But that completely confused these cases. The first one they cite from 1967, for heaven's sakes, was a medical payments case and had alternate holdings in it. It's not something that's controlling at all.
Counsel, so another ominous insured definition that we're working under, there has to be a connection between the liability, right, the accident arising out of the accident, right, and
Yes.
use.
Yes.
And to do that in this case, you're gonna have to have evidence of not only an implied permission from some chain. It could be the brother to the mother to the sister, or it could be the brother to the sister. But then you have to complete the chain, do you not, and have something from the sister to the boyfriend?
Yes.
Okay.
And that was the problem here. If they really had to prove up what we started the trial with, they were going to have, we can't, have no idea what she thought she knew.
And they selected one of those theories, did they not, in their liability action, which they got a default in?
They selected the standard chain in that lawsuit.
Which excluded the
then
mother, right?
they walked away from that. And I'm sorry.
I'll look at the DJA, I'll look at the coverage complaint again, but the coverage complaints theory excluded the mother, right? The chain was simpler, it was brother to sister to boyfriend. It may not matter.
There have been two different versions from the plaintiffs as to whether this was, the car was at the mother's house, but there's no evidence at all, and although mother was alive at the time this began, she's dead now, they never deposed her, so we don't know what her position was, but somehow the car disappears from either her house, which has been the predominant story, or possibly from Antonio Laura's house on Christmas Eve, and then is in this accident about 12:15 on Christmas Day.
But there's some cementing of the facts for which we make a coverage determination once that complaint for liability becomes a default. That has to be the facts under which the insurance company has to determine, and now for which a jury has to determine if there's coverage. It's not so much that you can change your argument midstream in the coverage action. Doesn't there have to be some cementing of the theory for which liability was ever imposed on Maggie Laura?
I believe that's correct, yes. We've got, because we're working off of judgments that were obtained based on that. They were admittedly that under these strange circumstances, they're default judgments, but that was the theory that no one tested in the underlying case, and that was part of what was going on here. But, since I don't want to run out of time, what I'd really like to emphasize is then, after we went through the directed verdicts and everything on this issue, suddenly we got to a change in this where what we are discussing is, oh, Judge, we've got one more jury instruction we want to use. And the instruction, which is never even filed, was use includes driving a vehicle or riding as a passenger. Now, riding as a passenger has never ever made anyone need liability insurance. It's useful for PIP or med pay, but it's not a use that's relevant to the insurance issue that was on trial here. But they abandoned all these things that they'd been arguing up to that point in time, and they hung their hat on she was using it as a passenger. Now, they're going to tell you that we didn't preserve this. Could have done a lot better job. But you know, the first thing an appellee needs to show you before they can start chiming on preservation is, did you give the other side a due process opportunity to prepare and respond to your argument? We're after the jury instructions have been resolved, after the DVs, which, by the way, we would have made a DV argument on this big time if we'd known about it. And so, at the beginning, we did object to this, but it wasn't very articulate. But you can't expect from a preservation standpoint, when they don't give you due process, to have that. We came back with a motion for new trial, and we laid this out. And all I'm entitled to really on this issue is a new trial. But
Counsel, it becomes very clear during the closing argument where they're going, correct? So I
Correct.
understand you sneak the jury instruction
Correct.
in, but during closing, when they start arguing their passenger theory, I see two objections in closing, and not to that issue.
But that's because the judge has just given and then told them that they're going to be an instruction that says that riding as a passenger is a use. So under the law that was being instructed to the jury, they were entitled to make that argument. It wasn't as a result objectionable, I don't
Counsel, what's the best case that you have that we should view preservation that way? I understand that preservation should not just be a simple barrier to appellate relief, right? That's not the reason it exists, to say, done, this is easy, you didn't preserve it.
I'm not sure.
It's supposed to have a functional purpose. I've always understood the functional purpose
So-
to, go ahead.
Your Honor, I object to this argument on grounds that you shouldn't have given the jury instruction on passenger because it was incorrect. That's going to have to be the argument. I remember making something like this to Judge Terrell Hodges about 40 years ago. He told me to stop. But I don't know that there's a case dead on point on that. I mean,
Incorrect statement of the law.
yeah, but it's an incorrect statement of the law by them that you've just authorized in the jury instruction you just read to the jury.
Can we approach?
And ask for a rehearing on the jury instruction? What am I supposed to do at that point in time?
Is it just your position that you don't need to keep renewing that objection in
Yeah.
order to preserve it?
Yeah, I mean, I got to come back on
So
rehearing.
it all comes down to the specificity required during the charge conference on the new instruction.
Right, and not during the jury, well, it's really at the very conclusion of the jury conference. We're getting this to read at the very end. The jury is literally in the jury room waiting to come out to hear closing arguments when we're trying to respond to this, which is why I'm saying I don't think preservation counts here. And if preservation doesn't count, this is clearly an incorrect way to approach the case.
Is there any case which says surprise obviates preservation? Would we be, is it obvious? What is?
I think a violation of due process. I mean, if what you're setting up is a gotcha here, because if you look at the closing arguments, you know, as we've said, you know, one of the lawyers comes in and says, all we need to prove is that she had permission from her brother to ride as a passenger with a car with him or his mother or Mr. Cruz. That's it, and we win. The two estates actually went beyond that and said, well, in this case, it was Antonio Laura who gave the car to Mr. Cruz, and all she needs to be an insured for liability insurance is to be a passenger in the car that her brother gave to Mr. Cruz. Well, she's not even in the bailment chain under that. So, I mean, I've been an appellate lawyer, been a trial lawyer. To stand up and tell the judge, I'm objecting to the argument because it's based on the jury instruction you just read to the jury, I'm not going to do that. I'm not going to tell the judge I'm objecting because you're just wrong. That's impolite and improper to the court. As an officer of the court, I have got to follow the law that the jury is being instructed with when I'm doing closing argument and when I object to closing arguments. I can handle it again on new trial, but I can't handle closing argument, I don't think.
So is your position that you adequately preserved it in that motion for new trial?
That's correct, only for a new trial. Now, I'm running out of time, so I'll rely on my brief on the front end issue. The front end issue was if we'd had the trial on the real issue, they could never quite prove up that Maggie had implied permission, that they were trying to use impeachment as substantive evidence, impeachment based on things from a trooper that should not have come in, when they didn't have evidence from the mother, from the neighbors, from anyone else that might support a theory that she had some reasonable belief that had implied to her that she could use his car as a drug addict with no driver's license, and on their theory, after he'd gone and picked her up someplace, and on the way back and told her, "No, I don't mind that you got picked and I had to come and get you, that you can go ahead and use the car." That's their
Counsel,
theory.
if you'd like 2 more minutes, I can add it to both sides.
Okay, thank you.
Counselor Appley, whenever you're ready.
May it please the court, I'm Brandon Cathy. I represent the estate of Maggie Lara, along with Mr. Brockmeyer, who represents the estates of Ms. Mounts and Ms. Franz. We thought if it was okay with your honors, we just divide our time 10 minutes and 10 minutes, and Mr. Brockmeyer would like 2 minutes on his cross-appeal rebuttal.
However you guys want to handle it, but you'll be in charge of keeping the time if that's okay.
Okay, thank you, Your Honor. So the first issue, the court obviously found that my client was an insured under the Security National policy. The court did that after there was a jury trial about the one issue that was in dispute between the parties for several years, which was whether or not this car was stolen by my client and her boyfriend, or whether or not they had permission to use it from Mr. Lara. That's what the dispute was at the beginning. That's what the dispute was still at the end. All 3 issues raised by Security National should be rejected. The case should be affirmed. The first one, it sounds like maybe Security National's conceded. It seemed like they did on page 6 of their reply that they didn't preserve any directed verdict motion on this argument that they
Counsel,
raised.
is preservation determinative of this appeal?
Yes.
If preservation is determinative of this appeal, and the jury was given instructions, which are a misstatement of the law, but we don't reach it because it wasn't preserved. There's a lot of talk in this record of a bad faith action that's going to follow your liability determination and your coverage determination. How does that affect your bad faith case?
There is no bad faith case. The lawsuit here was filed by Security National. They set the parameters of what they wanted to have determined. They wanted to determine that Maggie Lara stole the car and was not insured under their policy. They also wanted it declared that they didn't act in bad faith. They moved for summary judgment on that issue, saying that if it's a matter of law, they acted in good faith. Court said there's disputed issues of fact on both. And so now we have this second issue to be determined after this appeal is over, which is whether they acted in good faith or bad faith. But it's still part of this original declaratory action by Security National.
But
So
if
it is
the
on the table.
declaration that came out in your favor is defended simply on the fact that the errors were not preserved, are you saying that you no longer will have a bad faith case after that favorable coverage determination?
There would, to bring a bad faith case, of course, the person has to be insured under the policy. And so but that part has been determined, assuming it's affirmed. And then Ms. Lara.
But if it's affirmed only on the grounds that the errors weren't preserved, what does that ultimately do? That's my question.
I see what you're saying. If instead of affirming on the merits, it was affirmed only on preservation, what would it do? I think that what happens, it's that the declaratory judgment action that she's an insured is what's been determined, and whatever's outside of the scope of that determination is still, needs to be, if there's disputes about it, still need to be decided.
So if there's a decision that the merits, I'll withdraw my question. Go ahead, counsel.
Well, thank you, Aaron. So on this, I'll kind of skip ahead. I think the motion for directed verdict wasn't preserved. This idea that the plaintiffs were required here to put in, it was raised for the first time in appeal that the defendants were required to prove that Ms. Lara used the vehicle in a particular way, that she entrusted it to Mr. Cruz, that was part of what had to be proven.
Well, counsel, let me ask this. What evidence is there that Maggie Lara bailed the vehicle to Mr. Cruz?
It's inference. Similar to our permission situation here.
The inference being that she's a passenger?
No, there's more than that. We have the testimony of Mr. Antonio Lara, who is very clear. he did not give Joshua Cruz permission to use this car. So the jury can believe that. He didn't give it. So then who did? Why is he driving the car? Well, the owners, he said that the owner testified as his sister, the owner's sister is allowed to use the car if she's riding as a passenger. She's been pulled over 10 days earlier where he shows up to the scene to retrieve his car, never reports it stolen. There's ample evidence there to suggest that for a jury to determine that Maggie Lara had his permission to let Joshua Cruz, to use the car so long as Joshua Cruz was driving. Because who else could it be? The only person left is Maggie Lara, and it just so happens she's in the car with him at the time of the wreck. So all of that supports the inference that Joshua Cruz, if he didn't steal it and he didn't get permission from Antonia Lara, the only thing left is he got permission from the sister who's in the car with him, who's allowed to use the car when she's driving as a passenger, per Mr. Lara's testimony.
Counsel, if we look at that fact a little more closely, assuming, looking at the evidence of light most, favorable to your client, if Maggie is pulled over driving Antonia's car without a license, gets arrested, wakes him up, for whatever reason, summons him to the scene, so he has to collect the car. How does a reasonable jury infer from that that's okay with him, that she'd do that again sometime, or let her boyfriend take the car? I'm having trouble making that connection.
Well, there's the Christensen-Sullins case talks about this idea. They say that a failure to report the unauthorized use is evidence of the absence of conversion or theft. And so in the case, right, Security National saying it's their burden, they got to prove theft or conversion, and we have exactly that. 10 days before the wreck, he's at the scene of the wreck, doesn't report an unauthorized use, doesn't do it again on the 25th either when the police show up to his house to say, hey, my sister took my car.
Is there no middle ground or sort of gray area between permission to use a car and theft? I mean, conversion and theft I'm not even sure those are the identical concepts, but it seems like it's possible that there's something like, my sister took my car, I didn't give her permission to use it. I'm certainly not going to report it stolen, it's my sister. But it's possible for both things to be true, right? I don't consider it stolen, but I also didn't give her permission to use it.
Right. Well, going back to Roth, Susko, the Supreme Court's been at this for 70 plus years, but they've said we're not going to get into like what kind of agreements or arrangements. We don't even care if the rental agreement says you steal the car if you let someone drive it. We don't care about any of that. As soon as you let it outside of your possession, as soon as it's beyond your immediate control, permission is implied to anyone who gets that car.
But that's a dangerous instrumentality concept that once you give permission to one, then everything downstream you're liable for. But are we there? I'll ask you the same question. Are we really in that realm interpreting this omnibus insured policy where there's no question that the owner of the car is already covered, he's liable because he's an owner, and that's addressed in the policy. So are we still in that dangerous instrumentality land where that permission is sort of assumed, implied all the way down the line, or do we actually have to have specific evidence or specific proof of implied permission from Antonio to Maggie? And I guess your argument would be, well, not reporting it stolen is at least some evidence of that implied permission, and that's enough for a jury to for it to go to the jury.
It's one of the pieces of evidence that allows it to go to the jury. Yes, but the Chandler versus Geico is the case we would rely on. It's a pretty recent case. It's 2012, I believe. Florida Supreme Court. They go through the whole history, Blanton, Susko, all of them, and it's important because it's against Geico and it's about coverage. And most of those other cases, they're against rental car companies, right? They're against the owner. In that case, the Supreme Court says implied permission in an insurance policy for coverage means exactly what it means under the dangerous instrumentality doctrine. We want them aligned. We've been trying to keep it aligned this whole time, and so they still are. So when you're trying to figure out if there's implied permission under an insurance policy, it's the exact same analysis. And so the fact that Antonio Lara testified he let his mom drive it the same day, it's already now a jury question because he's given someone permission to use the car that day. And so implied permission is established. Now the burden goes to Security National. They've got to show some evidence of theft by Ms. Lara or the driver, and they weren't able to do that. The instruction on use, I just wanted to talk about briefly. The instruction on use is correct. even if it had been preserved. But let me talk about the preservation quickly. First, general objection at the charge conference, just we object to it. Trial court says, do you need more time? Do you want more time? Do you want to think about it? Offers all that up. Says, no, I don't need any more time to say I object. Case, goes on. An hour later or so, closing argument happens. Case ends. Nothing's brought up about this. Even in the post-trial motion, and I've got to disagree with my colleague here. In the post-trial motion, there's no argument made that they should get a new trial over this use instruction. There's an argument in the motion for a new trial that they should get the entire set, the form, the burden of proof, those instructions, the things that we've been arguing about on summary judgment over and over again, that there shouldn't have been this permissive use thing, it shouldn't have been a burden shift to proof theft or conversion. And then they make one little comment where they say, and this was amplified, this error, and given the set of instructions was amplified by the use instruction. That's the closest they ever came to saying that they should get a new trial based on this instruction. So the new trial on that use instruction was not preserved because it was never argued below as a basis for a new trial. But secondly, it's an accurate, the trial court gives an instruction if it's accurate, supported by evidence, and necessary. Here it's clearly accurate. We cited the cases. I heard today was said that it was inaccurate, but I've never seen a citation, anyone that says that use has got to be constricted to only driving. The cases, in fact, say the opposite. I'm covered, if I'm an insured, I might be covered even though I'm not liable. I've had several cases, right, where someone accused a passenger of reaching over and grabbing the wheel. So passengers can be liable for wrecks. But it might be that, well, you're covered because you were using the car. You were a passenger. You could be sleeping in the car. There's a mountain of cases about whether things arise out of the use of an auto. A kid being left in a van. All these things are use of a vehicle.
Counsel, your argument seems to disconnect the liability action from the coverage action altogether and try to put them together for one thing and one finding. What do you say to that? You have a liability action on entrustment, correct? Right. And now we're just going on use as her as a passenger. Doesn't the omnibus insured definition require a marrying?
It doesn't.
So she could be liable for something completely opposite for which we're asking for coverage for her to be covered for.
No, she's got to be liable for a use of the vehicle. It's got to be. She has to have been using the vehicle in a way that made her liable.
But doesn't that use have to relate to what caused the accident, what the accident arose out of? Doesn't have to be somewhat connected. She can just be sitting there.
It could be entrustment. She could grab the wheel. I mean, it could
be any. But entrustment is what she's liable for.
Right. But that's also that's also a use. But the policy doesn't say, we only cover you if your use is entrustment, is any use, right? And so the definition of use was appropriate.
But isn't that obvious under other grant of coverage provisions that counsel cited? The entire reason we're under the liability section of the policy is that she's liable, and she's liable under a theory, which you got a default judgment under, and we import that when we look at whether or not she's covered for liability based on that theory. You got a default under?
Yes, I mean we can look at the jury instruction. What was presented by Security National. One thing one had heard, and they wanted that one definition of who is an insured presented. They didn't ask about legal responsibility. They didn't want any of that. They weren't disputing any of this. They weren't disputing that she wasn't using it, that the accident arose out of her use. They agreed to that the whole case. It was not until appeal that they ever suggested in any way that they thought that her use was an issue in the case, that somehow the accident didn't arise from her use. And so the accident arose from her use because nobody disputed it. The question then just became, well, was that use one with Antonio Lara's permission? That's what was tried. So all we've had determined is, yes, the accident that arose from her use, she had permission to use the car. She is an insured, the end. There's a separate case. Agree, they were defaulted. Security National didn't get to fight about that. But they haven't been sued to pay the policy limit. They haven't been sued for breaching their duty to defend. They haven't been sued for bad faith, right? So there's nothing in this case that ever would have resolved, in the who is an insured case, that ever would have resolved any arguments they have about whether or not she was truly liable for giving the vehicle to Mr. Cruz. I see I'm burning through Mr. Brockmeyer's time. Thank you, Your Honors.
Good morning. May it please the Court. Alex Brockmeyer for the estate of Judy Mounts and Destiny Franz. Just, Judge Nardella, you're right. This case can be disposed of on preservation grounds. And I do want to talk about the jury instruction issue real quick because I think there's some confusion in terms of timing of how this all went down. The use instruction came up at the very beginning of the charge conference. I was the one who was doing it. There was a good 40 plus minutes that happened from the time that we did the use instruction to where this all concluded. This wasn't a situation where we said use instruction and Judge Estrada was like, jury's coming in. If you look at the transcript, I think it's a good 50 plus pages of transcript between when the use instruction objections happen on 2566 and 2567 of the record and when the actual charge conference concludes at around record 2613. So what we'll see though then is the case that was cited in support of that use instruction was Ray versus Earl. It wasn't like this was some novel case that I brought up for the first time during this charge conference. Indeed, the Ray versus Earl case was included in the trial court's order on implied permission and burden of proof, which was entered back in August of 2023. And the portion that I read from Ray versus Earl was pin site 70, I think it's 77 of the case, which was exactly the pin site given by the trial court on that order of burden of proof and implied permission.
Counsel, I thought the argument that was made in the initial brief was quite interesting on the fact that you never really got a determination of coverage that's pertinent. So the verdict form reads, was Maggie Laura's use of Antonio Laura's Buick on December 25th, 2018 with his implied permission? That question was answered after the jury heard a closing argument that they could determine permission just based upon her passengerhood, right? And so if that verdict was found, was Maggie Laura's use of Antonio Laura's Buick on that day with his implied permission to be a passenger, right? If the court finds that that's not enough and it has to be connected to the accident, what is your response that that's not worthless? That's not a worthless finding?
Well, my first statement on all that, Your Honor, is this chain of custody for dangerous instrumentality isn't preserved. It wasn't an argument they've ever raised at all. It never was raised at directed verdict. It wasn't raised at closing. First time I saw that argument was in the initial brief, and I thought to myself, I sat through it in a completely different trial. That question was answered based on the complaint that Security National framed the issue on. I didn't file a complaint for declaratory action. The jury answered the issue that they sought to have resolved, which was Maggie Lara's use of this vehicle with the express or implied permission of Antonio Lara. What Security National is now trying to do is rework subpart B of the omnibus insured provision in this contract and read language into it that does not exist. If it wanted a declaration that the threshold coverage grant was not satisfied here, it could have pled that, but it did not.
But for you to proceed to a bad faith case, don't you need a declaration that satisfies the fact that she's an insured? And did you get that?
Yes, we got that, and I would say to Your Honor, the issues for this court have nothing to do with bad faith. I would submit to you that's an irrelevant consideration. What should be considered is the issues that were presented on appeal, and what was presented on appeal in the first issue on appeal was not preserved. They've conceded that on page 6 of their reply brief. The second issue on appeal concerning the use instruction was not preserved as being an incorrect statement of the law, which is what they're asking you to hold on page 51 of their initial brief. The objection to the trial court, one that they clarified in an exchange with the trial court, was that it was not supported by the evidence. That is contrary to this court's decision in the Universal Property and Liberatory case, which is consistent with the Ellis v. Bohemy and Ellison v. Willoughby from the Florida Supreme Court. That was not the specific legal basis made on appeal that they made to the trial court. And so the jury answered the question that they framed. I didn't file a counterclaim. The estate of Maggie Lara didn't file a counterclaim. They asked for a declaration. They got it. They framed the issue. The jury answered it. And real quick on the cross appeal, this court doesn't have to answer it. It's moot if you guys resolve it on no preservation grounds or affirm on the direct appeal. But what I would say, and Judge Ganim, you had asked this question about, are we looking at the policy and what does implied permission mean? And that, I agree. We're asked about what implied permission means, and Chandler answered that in the context of a liability policy. and it said quite clearly that permission means that which is the owner consenting to the vehicle being used beyond his or her, or in the context of a rental car company or an entity, its immediate control. And viewing the light and the evidence in the light most favorable to Security National, that happened here. The undisputed testimony was that in Antonio Lara, according to him, which is what Security National wants everyone to believe, was that he gave this Buick LaCrosse and its keys to his mother, Elsie Lara. That's consent to the vehicle being used beyond Antonio Lara's immediate control. That's no different than Avis Rent-A-Car giving the vehicle to Shazier and Chandler. It's no different than in Thomas versus Atlantic Associates, the business giving the vehicle to the dad, or Enterprise and Dockery giving the car to the father, or in Blanton, the dad saying to the son, you can use this car. In all those instances, the owner said to someone else, you can use this car. The consent beyond the immediate control was given, implied permission existed, and at that point, the real issue, as Dockery and Thomas explained, became one of theft or conversion. So we were entitled to that directed verdict because Antonio Lara did consent to the vehicle being used beyond his immediate control. But again, this court doesn't have to answer that if you affirm on the direct appeal. And thank you.
Probably a lot more here than I can get through in my reply, but let me start off with the fact that this concept, the deck action was purely on whether there was coverage, and it was either did she have implied permission, express permission, or whether the policy had been exhausted by payment. We never really tried exhaustion of payment in this particular case. We never alleged that she had no coverage because the vehicle had been stolen by her. That came up in a motion for summary judgment that shows up at about page 219 that they filed. And in the process of determining burden of proofs in this case, in the underlying case, because of these arguments they've made, the trial court put a burden on us that was the secondary burden to prove whether the car was stolen or not. And Judge Gannon, you're right that if the jury first finds that she has permissive use to use it, it's virtually impossible for her to be a thief. This was something that really was sort of an issue that we couldn't prove for the same reasons they couldn't prove she had implied permission. There's just not enough evidence here to do that.
Is there a way for you to win counsel through the objection that your side actually lodged at the charge conference when they initially asked for the use instruction? Because if your argument on appeal is somewhat different, I wonder if I think maybe you pointed that out in the brief. Well, they still couldn't have gone forward with what they had, like there wasn't enough.
Right.
Can you explain that? I mean, if they're not entitled to that, is there a sufficient objection that was raised? Or now would I be getting too far afield from the briefing?
I'm not sure how to answer that second part, but I mean, the front issue of this was to try to prove that what we went to trial on, they didn't prove, and that should have gotten a directed verdict on that. And admittedly, they didn't push use the way I did, but they certainly pushed implied permission, and there was no evidence of implied permission, and that's the primary problem.
I understand that, but I don't know how you work around if your argument on use wasn't preserved and it's implied permission for that use, and perhaps they've twisted the prism on use,
Right.
but it's not preserved. Doesn't your implied permission argument fall too, or can you tell me why not?
Let me fight first on if it wasn't preserved. I encourage you to simply go back and look and read the record of when and how this takes place. The discussions that have been occurring throughout this record up to that point in time, there was never an argument that all they had to prove for her to be an insured for liability insurance coverage was that she was sitting in the passenger seat of the car. If that had been their argument, there would have been lots and lots of discussions on that. That comes up. I'm not exactly certain what they think's in those other 50 pages, but the opportunity to fight this ruling at that time was presented to us with about a minute to do this. And our fellows basically said, look, we object to this. We don't need this. It's not a use because use speaks for itself, and use speaks for itself in liability coverage for something other than passenger.
But he
So-
did decline extra time to go look at it.
They did, but again, the jury's sitting in we're gonna wait for 2
Okay.
hours and let the jury sit. I mean, it's tactics by the trial situation. They put us in a gotcha, and then they argued it, and go back and take a look at our motion for a new trial and how we added it to.
Do you
to
know where
that
you
as well.
added it? Because when you said it to me during your initial argument, my first thought was, oh, I didn't think that was in there. But honestly, I've read a lot for today, so it was
Yes.
possible I was misremembering, but then that's what opposing counsel
If my-
said.
If
Is
my
there a
notes are
record?
correct, if you look at 2843 of the record, you'll see where that's part of the new trial motion. It starts with a discussion about Emerson versus Lambert, which I'm not arguing, I was counsel of record in that. And then goes on to this and says, and this adds to the problem. So I believe it is there.
Okay, thank you, sir. Any questions?
I'm just about out of time, so unless you have additional questions, I'll thank you for your attention for this day. Thank you very much.
Thank you, counsel.
Thank
I want to thank counsel for both sides. You guys are welcome to, if you would like to stick around, if we have any students left. If any of the lawyers who argued today want to come up here, I can see if we have, do we have any students left? Looks like we may. Oh, wonderful. Well, welcome to Law Day.